daily all persons have anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to the Appeals Court. I am Justice Meade. Sitting with me today are Justices Desmond and Justice Wood. Will be the panel for all the cases we hear today. As you know, each side gets 15 minutes. You needn't use all of your time. We've read everything. My best advice is to get right to the point. With that, I'll call our first case, 25P612, Commonwealth versus CARDONA-GUEVARA.
May it please the Court, my name is Attorney James Methy, and I represent Sergio Cardona-Rivera in this appeal. The sole issue in my brief was that the motion judge should have allowed my client's motion to suppress his statements that he made during his interview with the police. First, I would argue that the judge's findings of fact were clear error. The judge indicated his decision that Dr. O'Loughlin did not get a complete history of my client along with his bilingual education. 1.5 pages of Dr. O'Loughlin's extensive report was basically on my client's background and his bilingual education. The 1.5 pages of his 13-page report, I would add. The motion judge also indicated in his decision the expert didn't determine the amount of time my client spoke in each language. It's right in the report that he spoke Spanish and English about 50% of the time, more English when he was at work and more Spanish when he was at home. The judge also, in his decision, stated that Dr. O'Loughlin didn't do a Spanish oral literacy test, which under cross-examination he said that he didn't do, but then on redirect indicated that his whole interview with my client was in Spanish, and including his Miranda test was all in Spanish. So he came to the conclusion that my client could only understand simple words in Spanish oral literacy.
But he didn't say he did the objective test of his oral literacy in Spanish, right?
Well,
he just spoke to him in Spanish. It wasn't a test.
I guess I would agree with that, although the Miranda is really a test. Asking him to repeat back the Miranda warnings, I think, was a test in Spanish.
Well, he could give self-serving answers there that the judge wasn't required to credit.
Well, he could, yes.
And he didn't. I mean, the judge, she didn't credit any, almost any of O'Loughlin's report or testimony, which you ask us to adopt.
Yes, because as I'm pointing out, I think a lot of his findings of fact are error. I mean, he's saying that these things
Mr. Methy, the judge is a woman.
That's right. Her findings of fact were, I'm arguing, clear error because she's saying these things in her decision which are not true.
Right, but even if we accept that she's made several erroneous factual findings, focusing on Justice Meade's point, she's permitted to discount the opinion if the answers are self-serving and unreliable because they're unself-serving, and on top of that, subject to interpretation. Those are the 2 points that your opponent will press. Forget about, I think, the point in a nutshell. Even if all of her other factual findings are clearly erroneous, these 2 points are material and sufficient to warrant rejecting Dr. O'Loughlin's opinion. That's the hard question for you.
Well, the case law indicates that this court can take an independent review of the evidence at the hearing and determine whether the findings of fact are correct and the conclusions are correct. Because you're in the same position that the motion judge is in. You have all the exhibits and you have a transcript of the hearing with the witness's testimony. So
We can't make credibility determinations on appeal.
Did you watch the video of the interview?
Of course I watched the video of the interview, yes.
And at any point during that, did it appear that your client didn't understand the questions that were being asked to him?
He's answering in Spanish, so
At any point, did it appear to you that he didn't understand the questions?
I suppose I would say it appeared that he understood.
Do you remember the part that I found interesting is when the Spanish-speaking officer translated something into English that was incorrect, and the defendant corrected him in English what the correct translation was, meaning he was following in English and Spanish.
Yeah, I did notice that a couple of times. Yes, he did do that.
Don't you think that's sort of telling of his ability to comprehend?
Well, I would just argue again, Dr. O'Loughlin, extensive credentials on languages and Spanish interpretation indicated that he didn't understand. So I don't know what was being said in Spanish. I understand what you're saying about sometimes he said something in English.
He never stopped and said he didn't understand.
That's true. He didn't say he didn't understand.
Did he ask for any of the questions to, we have a transcript of the interview, right? Did he
Yes, you
ask
have
for any of the
everything.
questions to be repeated? Do you have memory?
I don't recall exactly, but I don't think he did. But secondly, Dr. O'Loughlin's report, as you know, indicated that my client didn't understand prongs 3 to 5 of Miranda because basically he only understands simple words in Spanish.
Right, but trying to get to the 10,000-foot level. The core simple question is, in Spanish, does he understand the Miranda warnings? And we don't know. We don't. Dr. O'Loughlin, this is the fundamental problem. Dr. O'Loughlin doesn't give us any objective criteria, any test of Spanish language comprehension. And backing up a little bit, he's a lifetime Spanish speaker. So that would actually be kind of surprising that he doesn't understand in Spanish. So it seems like we really need some objective evidence from testing. And he knows how to do the testing in English because he did it all. But he doesn't do the equivalent objective testing. All he does is put it in your own words testing. And that, as the judge notes, I think reasonably, is subject to self-serving answers. We have no objective criteria for that core question. Is he following in Spanish? Like, how are we supposed to decide that? How are we supposed to decide that the motion judge got it wrong without objective testing?
Well, again, I would argue that Dr. O'Loughlin gave him the Miranda warnings in Spanish to ask him to repeat it back, and it was clear from the way he repeated the questions, the Miranda warnings back, he didn't understand prongs 3 to 5.
No affidavit from him saying that, right?
With the motion to suppress?
No affidavit from your client saying, I didn't understand certain questions during this.
Right, you're talking about the affidavit to be attached to the motion to suppress.
Right.
Right, there was no affidavit from my client, right.
Which is in violation of Rule 13, right?
Which the judge found was another reason to deny the motion, which I would argue is not, because admittedly there probably should have been an affidavit from my client saying he didn't understand, but the point of the affidavit is to give the parties notice, or particularly the assistant district attorney notice of what the evidence is going to be, and the judge, and clearly the assistant DA knew what the evidence was going to be because she introduced the exhibits and...
You're correct. Those are some of the purposes of the rule, but the one that's a problem here is they have to be averred to by someone with personal knowledge. It says that in the rule.
I understand that.
And you don't have that.
I understand that. I just don't think it's a reason, there was enough of a reason for the judge to also say, I'm going to deny the motion also on these
Well, I mean,
grounds,
she
because-
could have just denied the thing on the papers, right?
Pardon me, Judge?
She could have denied it on the papers.
I suppose she can do whatever she wants, but she conducted the hearing.
She can correctly deny it on the papers, let me put it that way.
I guess I would argue, she conducted the hearing. She could have said, why don't you just do a handwritten affidavit right now, or give me one in 10 days, but she didn't do that.
Yeah, but
She said, "We'll just conduct it."
she's a judge. She's not an advocate.
Well, perhaps the attorney should have said, we'll just write an affidavit right now, but.
Well, one
anyway,
thing the
it didn't
attorney,
happen,
I thought the attorney, one thing I thought the attorney said that was pretty compelling was, to quote Donald Rumsfeld, I don't know what I don't know. That's the problem here. The defendant, I actually do think there's an interesting question here, but it's not really for you, it's for your opponent. But how could a defendant in this context give personal knowledge of his understanding of Miranda warnings. I think that the rule, as applied to this context, is much more complicated, but you can speak to that if you want. I don't think it's clear that he could have given meaningful personal knowledge here. But again, I'm going to ask your opponent that.
Well, again, I just don't think it was an additional reason to deny the motion because everyone had notice of what the evidence was going to be, and she could have continued the hearing, et cetera, as I just said, and she didn't do that. She conducted the hearing with the witnesses and then made a decision. I would also argue that the error in the omission of my client's statements in his interview was not harmless beyond a reasonable doubt because the assistant DA, both in cross-examination of my client at trial and in her closing argument, hammered home the differences between his statements in the interview and his testimony at trial, which were where he got the gun from, and where he put the gun after the incident, and whether it was a pellet gun or not.
Yeah, but
He got acquitted of all of those charges.
Right.
Well,
So they certainly believed him.
But she's attacking his credibility.
Didn't work, though.
It did work.
The jury believed him.
Well, I don't necessarily agree with that because I think the reason they found him not guilty on the firearm charges is because they never found a gun. And it appeared that from his injury, it kind of looked like it wasn't bullet.
Yeah, but the arguments that you're saying the Commonwealth capitalized on all went to charges of which he was acquitted.
But my point is that she's attacking his credibility because he said something different in his interview than he said at trial. So she's basically saying, how can you believe anything he says because he said something different before? So there was a difference in the testimony. I mean, so it came down to Franklin, the alleged victim's testimony against my client concerning the charges he was convicted of. So I would argue
it
that
Well, he does have a bullet hole in his leg, right?
well, there was appeared to be some kind of hole in his leg.
Two holes? Two holes?
Pardon me?
2 holes?
Oh, actually, it looked like maybe there was an entrance and an exit.
And there's also a video of him pointing what either as a pellet gun or a real gun at the victim. So
Right.
that seems to by itself, and of course his admission that he did that in his own trial testimony. So putting that together, it seems that the charges of which he was actually convicted are supported by not only overwhelming evidence, but evidence that he concedes.
No, well, certainly not the intimidation and the threat charge. He never conceded that.
Right.
And actually, at trial, he kind of indicated that the gun went off accidentally, so he didn't even really admit at trial that he intentionally shot the gun.
Well, no, he did. On
Right.
on direct examination, he said, I intentionally shot the gun into the ground twice, maybe, and only on cross-examination does he change his tune.
Right, he was a little inconsistent, I will admit, on the trial testimony, exactly what happened there.
Right. It sounds like harmless error to me on the convictions.
Well, I would argue that it's not. But if the court has no further questions, I ask you to reverse the judgment and order a new trial.
Seeing none, thank you.
Thank you.
Mr. Crane.
Good morning, and may it please the court, Jesse Crane for the Commonwealth. The motion judge's ultimate determination that the defendant knowingly and intelligently waived his Miranda rights were well supported by the evidence and testimony at the motion hearing. The Worcester police officer who acted as a translator established that the defendant was given his Miranda rights in Spanish. There was no dispute that Spanish is the defendant's first language. There was no challenge to the adequacy of the warnings. The video and the transcript shows that the defendant says throughout the interview that he understands the Miranda warnings as he's given. And then throughout the interview, the defendant's responses are consistent, logical, and at certain points, the defendant makes critical corrections to the translation, showing he wasn't simply just going along or misunderstanding.
Right. So I think the judge makes the point, and you echo this, that the in your own words test about the Miranda warnings 3 to 5 can be appropriately criticized because they would be deemed self-serving, right?
Correct.
Right. I didn't understand what they were saying, right?
Correct.
And so we can, because on the video, he said, I do understand with regard to each of the Miranda warnings, right?
Yes.
And, okay, so here's my problem. Now, so whistling past the graveyard of the knowing, intelligent, and voluntary waiver, the affidavit that you're supposed to get under Rule 13, it doesn't say from the defendant. It says from somebody with personal knowledge. And in this context, if he's to say, tell me what he's supposed to say in that affidavit that is in any way meaningful to this motion to suppress.
So I think there's a relatively simple answer to that issue, and it's that get an affidavit from Dr. O'Loughlin, who has personal knowledge from doing the testing. He could establish, I mean, whether the judge credits it or not, and obviously she doesn't.
Okay, so, well, let's start there. That's helpful, actually. So you agree with me, I guess, that it doesn't have to come from the defendant.
I don't think it has to, but
Okay.
I mean, as I point out in my brief, it's sort of very telling that he won't aver to that.
Why is it, it's not telling to me, because to me, as we've just demonstrated, the only thing I can imagine he could say in this context, and I think this is kind of important for a lot of cases, is, I didn't understand the Miranda warnings. Well, why should anybody believe that? That's self-serving. That's utterly useless to the court. But an expert saying, as you suggest, he didn't have the ability to understand, well, that seems more compelling. But him saying I didn't understand is obviously going to be discounted as self-serving. And so why, if the point of this rule, as is illustrated in Clegg, is to give the judge and the prosecutor notice of what we're going to be arguing about, how can there be any criticism that the lawyer in his affidavit reporting what O'Loughlin's going to say and handing over the very long report is not sufficient for notice?
So I have 2 points. One is I think the defendant's affidavit and an expert affidavit and testimony, if it were credited, could work together in tandem to sort of rebut the Commonwealth's evidence of a knowing and intelligent waiver. I think the fact that there's no personal knowledge from the attorney leaves it open to the potential that on the witness stand we end up getting very different evidence than what's sort of averred to in the affidavit. So things could kind of go off the rails. I think
I'm struggling to understand the difference between Dr. O'Loughlin's personal knowledge and the attorney's personal knowledge in this specific context. Dr. O'Loughlin has examined the defendant and given him tests, and he's reported his results in his report. And the attorney has read the report. So it's not his personal knowledge of what's going on in the guy's head. It's his personal knowledge of the results of the tests and the interviews. And so what's the meaningful difference between Dr. O'Loughlin's personal knowledge and the attorney's personal knowledge of what Dr. O'Loughlin did? How is that, and to apply it to this rule, the notice that the judge and the prosecutor need, how are they prejudiced by that distinction in personal knowledge, whatever it is?
I think, to be quite frank, it is, I think the personal knowledge, the issue of notice, the ship kind of sailed on that because we had the hearing, right? Like, the trial, the motion judge received evidence, and so in terms of denying the motion on the paper, it almost sort of doesn't matter. I think what the motion judge was really ultimately saying in her decision in that final paragraph was simply, without anything credible from Dr. O'Loughlin, I have nothing, not even a bare assertion from the defendant that he didn't understand that I could credit or discredit. I think that's really the heart of what she's saying in that final paragraph. Like, I have nothing else to look at. I don't credit Dr. O'Loughlin, and you've given me nothing else.
Thank you. That's a great answer.
This defendant was originally from Honduras, is that correct?
Yes, that is correct.
How old was he when he moved here?
I candidly don't remember. He was quite young. He was ultimately put in foster care when he arrived in the United States. So he was a minor.
Has this court or the SJC or any court set minimum educational achievements for being able to understand Miranda and waive it voluntarily?
No. It's a totality of the circumstances examination. If there are no further questions, I'll rest on my brief and just note that the motion judge was well within her rights to discredit Dr. O'Loughlin's conclusions.
Thank you.
Thank you.
Thank you both. We'll take it under advisement.
Thank you.
Our next case is 25P 626 Commonwealth versus Porter. Ms. Renown.
May it please the Court, Suzanne Renaud for KELSCO Porter. Your Honors, this case comes down to whether the exit order was lawful or not, because all of the evidence that came out of that was fruit of this exit order. So, and Mr. Porter submits that the judge here was in error when he said that the exit order was justified. This exit order is really controlled by Commonwealth versus Gonzalez, where the SJC basically said that cars, they're acknowledging the federal case law that says that cars have inherent dangers to them, but yet said individuals have a right to be free from coercion and to maintain their autonomy, even in light of any kind of danger that's inherent in a car stop that a police officer is going to engage in.
They also said in Gonzalez and Stampley that the standard is painfully low, that you have to make just a bare showing at all of concern, among other things, of officer safety.
Well, Your Honor, it still is, yes, that is absolutely correct, but it still is individualized and fact-based. And there are actually a number of cases that have come out since Gonzalez that have rejected exit orders. And so Commonwealth versus Shaw, which is unpublished, but I've provided that to you, is one of them. Barreto is another one. I could provide you other names of other cases. So even though this standard is very low, it's not non-existent, and it certainly has been challenged in the appellate courts over time. And the problem with this case is that there was one factor. It's not a combination of factors. There was one factor that Judge Julian focused on and that really presented itself here.
Which factor do you think that is?
That was the behavior of the defendant. That's what he cited.
That's a critical factor, right?
I'm sorry, Your Honor?
That's a critical factor.
It is a critical factor, but I do want to walk through that factor and why that wasn't sufficient in this case. And I'm sorry, I keep hitting the microphone too loudly.
So the officer is familiar with this area in, I want to say, Hyannis, maybe?
It's in Hyannis.
For having received some calls.
But it's not a high crime area. So I want
He
to,
didn't characterize it as a high crime area. He said he's familiar with this area. He was patrolling this specific area because of calls of domestic violence and I think he even said weapons or
Disturbances involving
disturbances,
weapons.
correct. But this is a car stop.
I get it.
Yeah.
It's 12:25 or so in the morning. And there's no question that he lawfully stopped the car. I think I read that in your brief. You can see that the stop was legit.
The stop was legitimate because at that point he was investigating whether there was a crime that had been committed, whether or not the person who was driving was an unlicensed driver. So it had nothing to do with that environment. So he stops the car.
And in accepting that it was a lawful stop,
It was a lawful stop.
we accept that the windows were tinted such that he couldn't see the driver of the car.
I'm going to push back on that a bit, Your Honor, because what happened was the car stopped in a timely manner.
No,
The officer,
before the car stops, he sees the car go by him, right?
well, yes, so
And
there were two things.
And he queries the plate, and he said, I can't see the driver in the car, so I don't know if it's the person who has a suspended license.
That's completely fair, and all of that legitimizes the actual car stop to begin with, but doesn't get to the driver's behavior, and that's where we're going to head now.
I get it.
So,
hold
go
on.
ahead. Sorry, Your Honor.
So he approaches the driver's side window, right?
Correct.
And what happens then? Does
Well,
the
I'm
does
sorry.
the driver lower the window all the way down? Does he lower it halfway? Does he lower it three-quarters way? Is it three-quarters way up?
So it's down. It's a half to three-quarters of the way down. And this is why I wanted to focus on this. The car stop was legitimate. The car stopped in a very timely manner. The officer approached and the window was not yet down, but by the time the officer got there to the window was down halfway to three-quarters of the way, to the extent that the driver had no problem seeing inside of the vehicle because his lights were on in his cruiser, seeing inside of his vehicle, seeing what Mr. Porter was doing, talking to Mr. Porter, and getting his license.
And it was what he was doing that caused the concern.
Yes, Your Honor. So that's the next part of it. I just want to make sure that it is clear that whatever this approach issue is, that's really not focused, that's not the factor here, because
There's also marijuana smoke billowing out the windows.
the officer had no concern about that, nor did he think
Officer
it was a
Stoner.
crime. Officer Stoner said it.
Can't make this up.
It's true. I hadn't thought about that, Your Honor, after all this time reading this.
Far more juvenile than you are.
I know. But so this is the issue. He's talking to Mr. Porter. Everybody seems calm and not nervous in the vehicle. And Mr. Porter is doing one thing that's explained on pages 10 to 11.
Why do you think he makes a note that the window only comes down halfway or three-quarters of the way and not all the way? Why do you think that that is noted?
Your Honor, I do not think that a reasonable officer in his position would say, this is something that puts fear in us officers, which is what his testimony was.
I'm asking you why.
That was why he noted it, because he personally has been 1 year on the force, and he noticed that the window wasn't all the way down when he walked up, and he brings it out on examination. But honestly, Your Honor, this is not a subjective standard, it's an objective standard, and no reasonable officer should be afraid when their window is actually down to the point where he can see into the car and communicate with the driver, which is all that is required. He didn't have to tell the driver to put the window down. The driver put the window down himself, so it wasn't even like there was any kind of delay that was created by the driver, Mr. Porter.
When he put the window partially down rather than all the way down, why isn't it reasonable to conclude that he was still trying to conceal what was going on in the car?
Your Honor, I think if that's the standard we're having, then every single stop is going to be subjective.
No, it's just one factor. But then he looks in, the defendant's moving in the seat, he has his hand draped over the console, he keeps shifting his body towards the console, and he's constantly repositioning himself in the car.
Well, Your Honor, again, I think that when the window is down enough, officer didn't ask him to put it down further, three-quarters of the way down, maybe the car shut off before the window went all the way down.
Let's forget about the window. Let's talk about his behavior.
So what he's seeing is a person who took out their wallet. They're seeing that two persons in the car, presumably it's a Honda, it only has two seats in the front, there's a console in the middle. Our common sense tells us what's in that console. It's a shifter, it's cup holders, and then there's some bit that we know is covered because it had to be.
Or there's a gun in there.
Armrest. It's an armrest.
When this objective test doesn't require the officer to exclude hypotheses of innocence.
I'm going to.
Which is what you're asking us to do.
Actually, that's not correct, Your Honor. You don't exclude hypotheses of innocence when you have a combination of factors. What we don't have here is a combination of factors, because what is happening is what the officer in his 1 or 2 sentences describes is a person whose arm is on the armrest. Either his hand is on the armrest, visible in there, or his arm is on the armrest and is flopped over where the cup holders would be.
Draped.
Draped. What it is not doing, it's not concealing, it's not hiding. He's not going down. He's not reaching in between.
He's moving around in the car and moving his body towards the console, from which one could conclude he's trying to conceal what is in the console.
The console is closed, Your Honor.
But if he blocks his view from the side window by moving his body and positioning it closer to the console.
He's turning his. He does not say.
He shifted his body. It says was shifting his body towards the console.
Is there any evidence, I can't remember this.
I'm
Is
sorry.
there any evidence about whether the console, the container part, was in fact closed?
It was. I think when they talk about doing the search, they said they had to open it. I immediately opened it.
Okay,
And then
thank you.
And I found it. But the point of this is there are so many innocent reasons, which could be latent nervousness. Maybe he's uncomfortable after taking his wallet out, and maybe he has ADHD, or maybe he's just a fidgeting person.
Maybe he has a gun.
Maybe he has a gun.
Does the officer have to wait to find out which it is?
No, but in this case, there are so many cases that talk about somebody's movement not being enough. And I'm going to just cite one. I know that this wasn't cited in the case, the brief, and I apologize for that, but Commonwealth versus Hooker, which is 52 Mass Appellate Court 683, which says, not every turn of the head is a furtive gesture causing the defendant a fate equivalent to that of Lot's wife.
Hooker was in the back of a taxi, right?
Yes.
Yeah.
But the problem, what you have here is you do not have an officer testifying about his training and experience.
Was the officer discredited in any way?
No, but he is not testifying in his training and experience that things are hidden in these consoles. He's not testifying that Mr. Porter's hands are secreted. He's not testifying about trying to secrete anything. He's not testifying about trying to grab
He's not worried about him hiding anything. He's worried about him retrieving something. And the
Your
officer,
Honor,
several cases have said that the officer needn't bet his life on the possibility that one of these innocent details may be going on.
But they all have more facts than this.
Sure.
That's the difference.
He didn't make any observations of the passenger doing any of those things, right?
He did not mention any.
And when he made the exit order, did he have both passengers? Did he have both? Just the driver got out.
He just had the.
He only ordered the driver to get out.
I want to just add.
No, my question is, he only ordered the driver to get out. Is that correct?
He did.
So he didn't see any furtive or any movement by the passenger, and he didn't ask the passenger to exit the car. Is that fair to say?
That's fair to say.
Okay.
But I want to also point out that when he was by himself. Again, this is a de-escalating situation where all they were doing at this point was waiting for a tint meter. While he was by himself, he did not order Mr. Porter out of the car. It wasn't until a second order officer came and he was no longer outnumbered that he actually took some level of action. And so,
I think he did that because he was concerned for his safety? Why do you think he did that?
I think he did that because the other officer told him to. But it doesn't come out and that's just an interpretation of reading through the lines because this officer only had 1 year of experience. But I don't know that because that's not what he testified to. What he said is that it is, I considered this to be something that might put me in fear, and so I did this. But whether or not that was a reasonable fear is the question that's before the court. And you have an officer who's only describing visible hands visible at all times, and a person who is essentially what Barreto would call fidgeting and moving around. It is not the same as reaching. His hands were visible. That is what the officer is saying. If
One man's fidget is another man's furtive gesture.
But if the hands are draped over the console area for whatever period of time while the body is moving, that is not a furtive gesture. And there is absolutely no evidence from the officer describing this as being a furtive gesture that he has learned in his training and experience would be suggestive of
What was the make of the car?
It was a Honda, I think it was an Accord. It was a sedan, from my recollection. I definitely know it was a Honda.
So the activating button to open the console would be at the top.
So it would
the front.
probably be under, usually those.
The front.
Would
Yeah.
be in the front.
Where he's draped his arm.
Officer didn't testify to that, Your Honor.
He draped it, so.
He had it
Unless he
draped
was sitting
over the
backwards in
console.
the car, he draped it this way.
He had it draped with his hand over the console or potentially. But, Your Honor, I think what you're trying to do is go back and reconstruct this. What a reasonable officer would say is this is an inherent danger in the car. Cars have glove boxes. Cars have areas. People can sit near those. The problem that you face when you're dealing with reasonable suspicion under Gonsalves is whether or not that suspicion, that action is more than just that typical action. And especially in a case like this where you have nothing, no plus factor, no other factors. You only have this. You can't discount the innocent version simply because it turned out he was correct in this particular case. That's not the constitutional standard.
They were smoking marijuana. One could conclude they were smoking marijuana.
Or at
They
least
may
the
be
passenger
impaired.
was.
He knows the license of the operator is suspended.
No, both of those are incorrect. He did not conclude that anybody was impaired, and in fact, he let the woman drive home. And secondly, there was no indication that Mr. Porter had a suspended
Not
license.
him, the uncle who owned the car.
Oh, I thought you said the operator, Your Honor.
No,
I'm sorry.
it's owner.
The owner, yes, and the owner did not drive the car away. The passenger ended up driving the car away. So, but by then he knew that Mr. Porter wasn't the owner of the vehicle. So I think that this is, this is one of those cases that, there are more facts in Commonwealth versus Shaw. There are more facts in Brito. There are more facts in all these other cases that still didn't say that an exit order was justified. I think when all you have is a person who has ants in their pants, essentially, and that is what draws the officer's attention. The fact that his hands remain visible at all sides does not turn that into a furtive movement and does not turn it into a reaching, grabbing, secreting, or anything else that indicates that level of action. And so I think that is where the problem lies in this case. All he's identifying is the car has an armrest, and an armrest could have a weapon, and that's it, and that's not enough.
Once he's out of the car, he consents to the search?
Well, that's too late, Your Honor.
I understand. Does he consent to the search?
He did consent to the search in those coercive situations, so it's still
Did the judge find that he voluntarily consented to the search?
Didn't make a finding about the voluntariness of the search. He made a finding about the voluntariness of the statement regarding ownership. So, so I think that if the exit order issue failed, I don't think that there is a coercion issue following that.
Thank you.
Thank you.
Ms. Sweeney.
Good morning. May it please the Court. Elizabeth Sweeney for the Commonwealth. The motion judge properly denied the defendant's motion to suppress after an evidentiary hearing, finding that the exit order, limited search of the vehicle, and the statement of fact to the defendant that both him and the passenger would be arrested was permissible. There's nothing extraordinary about this case. Judge Julian did very thorough findings after the evidentiary hearing, and there's no credibility issues found on behalf of the officer. Turning first to the exit order. The standard, as this court is well aware under Gonsalves and Torres-Pagan, is a reasonable, prudent person in the police officer's position. We don't need to discount hypotheses or innocent explanations. And applying Torres-Pagan, the exit order was justified where the police are warranted of finding a safety threat. And here, directing the court's attention to transcript pages 10 and 11, where the officer testified about the movement. He said that the defendant was moving and shifting throughout the driver's seat with his hand draped over the center console, his body shifted to the console with a constant repositioning.
Right, so there's no fidgeting, first of all. I don't know where this word fidgeting comes from, but he never said fidgeting,
There was no fidgeting.
Right.
The judge
it's moving and shifting. Let's just be clear about that.
Yes, sorry to interrupt you. The judge in his findings on page 34 and 35 said that it was moving and shaking. I couldn't find shaking. I saw moving and shifting.
Right, there's no shaking and there's no fidgeting. There's moving and shifting. Okay, go on.
His entire body towards that console, and it's draped over, his arm is draped over.
And focusing on that, his hand, singular, hand, draped over the center console.
Yes.
So my interpretation of that is the right hand draped over the center console.
Yes.
And his left hand not anywhere near the center console, right?
There's nothing about the left hand on the record, so one would presume that the left hand is not on the console.
Now, what about your opponent's point that the center console doubles as an armrest in any normal car?
I would agree that the center console does double as an armrest.
Right.
However, the arm on the console isn't all we have here. We have the body moving and positioning itself and moving and shifting, the body shifted to the console with a constant repositioning. And I think that
Is there any reaching? Did he ever reach?
The word reach is not in the transcript. It's moving and shifting throughout the driver's seat with his hand draped over the console.
Right, it seems to me that moving and shifting is his torso, right?
Again, just reading that very limited description, yes, I would say it's the body shifting to the console, assuming that's the trunk of the body.
Right, and his hand, the thing we're worried about, the thing that could be used to kill the police officer, is draped. The hand is never moving, the hand is draped, and as far as we know, sitting still. There's no reaching, right?
Correct. On that console, which to Justice Meade's point is the area where, one, the gun was found, and two, all it would take is, not in the transcript, but a press of that button, and his hand is already on that console.
Right.
So as far as the exit order, we have those observations which are sufficient because an officer isn't supposed to, we're not supposed to apply hindsight, and we're not supposed to gamble with an officer's life as he's observing this behavior that gives him, in his 1 year of experience, concern to the extent that he calls another officer to respond.
Right. On that point about we're not supposed to gamble with the officer's life, I'll quote from Terry v. Ohio, the seminal case. The scheme of the Fourth Amendment becomes meaningful only when it is assured that at some point the conduct of those charged with enforcing the laws can be subjected to the more detached and neutral scrutiny of a judge who must evaluate the reasonableness of a particular search or seizure in light of the particular circumstances. So what I read from that seminal case is it's exactly what we're supposed to do. We're supposed to look at this from our perspective as judges, as the trial judge was, and try and figure out if what the officer saw was a reasonable threat to his safety. In other words, we're not supposed to defer to the officer's concerns. Is that a fair reading, in your mind, of Terry, the Supreme Court case?
That is an absolutely fair reading, and
Okay.
directing the court to the paragraph of my brief that defense counsel referenced in her reply brief when I was describing the hindsight of the court isn't supposed to apply hindsight as to what the officer could have done better. We're supposed to apply the Terry standard. I completely agree with you.
Okay, and now it's officer safety. That's what we're focusing on, right?
Yes.
It's not a crime. We're not he's not using the crime exception or basis. He's using reasonable suspicion of a crime. He's relying on reasonable suspicion of a threat to officer safety, right?
As cited in Torres-Pagan, yes.
Okay.
And Williams, I would also direct the court to Williams, 46 Mass App Court 181, where there is a danger inherent in every auto stop.
Yeah, so that's kind of a problem for me. I mean, first of all, if you're going to quote that, I guess I'm going to say, well, wait a minute. Every auto stop. Well, there are auto stops and auto stops. Here, the auto stop is for suspension. The driver has a suspended license. I'm sorry, the registered owner has a suspended license, not a violent crime. That's what the officer thought he was dealing with. And when he gets up to the window and it comes down 3/4 of the way and he gets the license, actually before he even gets the license, he knows this is not the owner of the car, right? So in fact, he knows the thing he stopped him for before he even gets the license is not a thing that he can arrest this guy for. The only thing he's concerned about now is a civil infraction, the tint on the windows. Is that all fair?
That is fair, and
Okay.
we have, again, it's, I believe, 1225 it's not described as a high crime area, but an area of Fresh Holes Road in Hyannis with numerous calls for weapons and domestic violations.
Right, and if we're going to talk about that, do we know at that point if he's from that area? Do we know if he's driving through that area? I mean, it's 12:25 in the morning, so I guess it's a fair inference that he's probably not driving far, but we don't know if he's even from this area that's not a high crime area, but an area where there's been a lot of calls for other things that are not this thing,
The
right?
record is absent as to that fact, but I can say that I looked up in prepping for this case, and the defendant does appear to be from that Fresh Holes Road of
Right,
area
my
of
point
Hyannis.
though is, did the officer know that at the time of the stop?
That's not in the record, and
Right.
so I would say no, where it's not in the record. So, but again, we have the judge making that finding, as well as the window coming partially down to perhaps block in light of the fact that he's moving and shifting his body.
Right, and on that point, the officer, I think it's fair to say, testifies throughout the entire stop. He characterizes the defendant's behavior as both compliant and relaxed. And he's clear about this throughout the entire stop. His behavior is compliant and relaxed, right?
Yes.
He stops immediately when the blue lights go on. He immediately rolls down the window, right?
Yes.
He immediately gives the officer his driver's license, right?
As he's moving around
Right.
there wasn't a delay, there wasn't I'm not going to give you my license or any sort of back and forth.
Right.
I believe it's described as that they were respectful, but again, one can be hiding contraband in a firearm and believe that it's hidden and still be respectful to the police officer.
Sure, but applying Terry and exercising our constitutional obligation to review this totality of the circumstances for reasonableness of the
Yes.
officer's judgment, we can figure out whether there's anything else besides the draping of the arm and the moving of the torso, right? And we have to decide whether, so far, it sounds like the guy is compliant and relaxed, and we have to decide whether the draping of the arm over the center console and the shifting and moving of the torso is a reasonable basis for to threaten officer safety.
A reasonably prudent person in the police position would, the issue is, would an officer determine that behavior, and the court view that behavior as applying Terry and determine if there's reason for an exit order. So
Right.
again, we have the hand in the area where a firearm could be stored.
Right.
As the court mentioned earlier, the console has the lift up with the button. Again, that's not in the record, but I think we can agree that that's how the console is made. Moving towards it, shifting his body, tinted window. The window's not entirely all the way down. Obviously, the officer's view is somewhat blocked where it's not completely down.
Is there any testimony about that? I don't remember any testimony that because the window was, well, whether, I know that the window came down half to 3/4, that's what he testified about that. Is there any testimony that the officer's view was obstructed? He could see his hand draped over the center
There's no
console.
testimony, but if the window's partially down and it's
Right.
that dark tint, you can't see as though it was
Right.
completely down. So
Right.
that's the only point that I was
Okay.
making.
Okay.
So again, not rolling it down, moving his body. So the court needs to analyze whether or not those movements of shifting the body in an area with DV, violence, and weapons at 12:25 in the evening, in the morning, with his hand draped over the console, where one could access a weapon, is reasonable, and the Commonwealth
And
suggests,
you,
based on the cases.
It's not, you didn't put it in your brief, but as long as we're quoting Terry this morning, there's a nifty concurring opinion by Justice Harlan in which he says every police officer knows the answer to investigative stop may very well be a bullet.
Exactly. And as I do put in my brief, that the court is, I think I used the term second guess in applying hindsight. This officer was concerned based on this movement. Is he supposed to see the defendant making these furtive movements and then just walk back to his cruiser and gamble with what his
Right,
his
so
life?
the safest thing to do, right, in that, given that, Pearl from Justice Harlan, it seems that the safest thing to do is to, at every police stop, at least at night, I guess, in a certain neighborhood, to just order the defendant out automatically. That's the safest thing to do. But in Gonsalves, the Supreme Judicial Court explicitly rejected that option, right?
So I would not agree that the safest thing to do, if somebody's not moving around and they're not shifting their body and they're compliant, then there's no safety concern.
Right, but my
12
point is there's a standard that the officers have to meet, notwithstanding that every traffic stop could result in an officer's death. In order to issue an exit order, which is not an insignificant infringement on someone's liberty, the police have to meet an objective standard based on specific and articulable facts. We all agree what the facts are here. The facts are twisting his torso and draping his arm over the center console. Now, the exit order, very quickly, you don't have a lot of time. The exit order, he's given the exit order, he doesn't complain, he doesn't do anything, he gets out of the car, he's fully compliant, right? And this issue about consent, am I right that the judge made no finding that the defendant voluntarily consented to a search of the car?
I didn't see a specific finding about the voluntary consent. There is an analysis of when the defendant responds, when the officer says, "I will charge both," as to the defendant's.
No, that's later as to
Right.
who owns this, right? I'm talking about the consent to search the car, right? So if there is no finding, we're not allowed to make findings. Is the Commonwealth relying on the voluntary consent to search as a justification for the search?
No, in my brief in that issue, I analyzed it at first that the officer can do at that point a search of the console. He searches in the side door, where that, again, that window isn't all the way down. Quick look in there, and then in the console, and finds the weapon.
Right.
He didn't do a
Right.
full search of the car. He didn't open the trunk at that
Right.
point. Very limited cursory search, which he's permitted to do under Daniel case
Right.
law. And as far as consent goes, I would argue that the defendant did consent. It was very relaxed demeanor. There were two officers. There was no overt coercion, threatening.
Wait, sorry, I just didn't hear you. I think you said the defendant did consent. Is that what you just said?
Yes.
Right, but if the judge didn't make that was my question. If the judge didn't make a finding that his consent was voluntary, are we allowed to rely on consent as a justification for the search?
I would argue, yes, the judge didn't find there was not consent. He just didn't analyze that issue.
Who has the burden on an exception, a warrantless search
The
justified by
Commonwealth,
consent?
A Commonwealth would
Right.
have that burden.
And, okay.
Is that raised in the motion to suppress?
I believe it was in
The validity of the search?
I don't recall. I apologize. I know that there's issue with consent.
I don't think it's not in the motion.
Okay.
So, at bottom, it seems to me that you have 12:25 at night, an officer who's outnumbered, he's by himself, and there are two occupants of the motor vehicle.
Yes.
The windows are dark tinted and don't come all the way down when the officer approaches. There's a constant repositioning. I don't know about torso twisting, but there's a constant repositioning in the vehicle while seemingly in the area of the center console.
Yes. When I said body repositioning, it says his body shifted to the console with a constant repositioning. So I think the body is the part that's moving.
And the officer, at that point, is that at the point where he asked the operator to get out of the car?
Yes. If there are no further questions, I rely on my brief.
Thank you very much.
you.
Thank you. Thank you both. Our next case is 24P1188, Commonwealth versus BOWMAN. Mr. Ellison.
It is Mr. Ellison. Good day, sir. If it may please the court, Anthony Robert Ellison on behalf of Mr. Reginald Bowman. If it may please the court, this case comes out of the Boston Municipal Court where a motion to suppress was denied. In terms of the issue at bar here is really whether or not an anonymous tip given of a person or persons exchanging or passing off a firearm to the other is enough for the officers to later stop Mr. Bowman based upon this anonymous tip, based upon the, I would suggest to the court, lack of particularized description of the assailants and the lack of a crime, quote unquote, being committed. My main issue with the court's final analysis and conclusion was that the court believed, and that there was reason to believe, that there was an armed robbery afoot. I thought the court, that was just a bridge too far in terms of where the facts of the case.
Let me ask you this.
Go right ahead, yeah.
The officers, just so we have some context, get a call at 2:45, 2:53, I think it is, in the afternoon, about an anonymous caller who later refuses to identify himself.
True.
Says, I just witnessed a young black male kid in a red hoodie pass a gun to a young black male in a black hoodie as they entered the Nike store.
Yes.
And my son says, and we don't know anything about the son, that maybe the gentleman with the black hoodie also had a surgical mask on. Is that fair for starters?
That is accurate.
Okay. So it's reasonable. Would you concede that it's reasonable for the police to go to the Nike store?
Yes.
Okay. And the police go into the Nike store, and there's 100 to 150 people in the store or around the store.
Yeah,
What I read?
50 to 100 people.
50 to 100?
In or around the Nike store.
Okay, I thought I read 100 to 150, but
Yeah,
50 to 100. I'll take your number.
Well, I'll take your number.
All right.
It's 50.
And they go into the store, and they don't seem anything that seems out of sorts. They look around, they see a bunch of people in there, they see The guy with the red hood and the black hood, they don't seem to be doing anything unusual. They ask the store personnel, anything amiss here? Store personnel says everything's fine. Police leave, right? They didn't stop anybody. They didn't approach anybody. They leave the store.
Right.
What happens next?
My client, Mr. Bowman, gets up, walks out of the store.
Does that happen first, or does the red hood and somebody I saw with a gray, I looked at a video, somebody I saw with a red hood and another young black person with a gray body hoodie, but a black hood, come out of the store?
That's what happens first before my client leaves.
And when they come out of the store, are they with somebody else?
2 others.
Is there at least another black guy who seems to look fairly sharp? He's got a scarf on, he's got like a gray, maybe a camel jacket. He says, I'm just shopping, I don't even know these 2 guys. Is he stopped and actually pat frisked before he's
I don't believe
excused?
that. I don't think he was pat frisked.
Before the fellow in the red hoodie, right? Doesn't he extend his arms?
He does.
So
yes, he does.
I'm taking he's not marking the score of a touchdown. That he's indicating that he's not armed.
So is that the red hoodie or the black hoodie?
That's red hoodie.
Red.
When I'm addressing
And there's no
Justice
gun on.
Meade.
There's no gun on
On
the
red
red
hood.
hood.
Is that an expression of consciousness of guilt? Where specifically, I don't have a gun.
If I could just, I don't believe so. What I would suggest is when 15 to 20 police officers show up or gathered outside the store and they're eyeballing you, you may, just wonder what is going on. And if approached, you may be like, hey, you put your hands up. I don't see that as necessarily a consciousness of guilt.
No, it's actually a consciousness of innocence.
Well, yeah, it
But
could be viewed the other-
importantly, though, the officer Kearney, now he knows that Mr. Red Hoodie doesn't have a weapon on him, and there's still a weapon somewhere. The weapon that was passed to Mr. Bowman, who put it in his pocket.
Well, does he know that? I mean, is that tip, what is that, what's the value of that tip? Given that the caller refused to identify himself, do you agree that that's an anonymous tip?
Oh, absolutely. I think,
And what does our case law say about the value of anonymous tips?
Well, it isn't accorded the same credibility as in the reliability sector or prong of the
Right, there's 2 prongs, right? There's the basis of knowledge and the veracity reliability prong, right?
Correct.
And at least before those 2 prongs are satisfied, what's the value of the tip?
Well, what is the value of the tip? I guess you would have to go back to what inherently in the tip is illegal about the tip. So I guess
Can I on the question of anonymity, they called him back.
They did. They did call
they
him
knew how to
back,
reach him.
And when they called him back, ultimately, he said, I don't want to get involved.
Right, he doesn't want to get involved.
Hey.
But since they were able to call him back and record, it wasn't entirely anonymous. It was someone who was reluctant to participate in the criminal justice system and didn't participate other than the phone call.
Justice Meade, or Justice Desmond, just let me answer that briefly. This court, most recently in the case of Commonwealth versus Morales, where Justice Desmond penned an opinion citing just that issue, I think it's clear and it's well established that under these set of facts that mirror that of Morales, that it is an anonymous
I guess
tip.
what I was getting at is I'm not saying it makes him a named informant. All I'm saying is that it's not nothing. They can find him if they need to, and making a false report to the police is a crime.
Can I ask on that, the factual record, the 911 tape, I couldn't find quickly the transcript of the 911 calls in our record. And I'm trying to find out if he mentions the gun only in the first call before they call him back, and if that's legally relevant.
I understood it to be in the first call.
Is that what they call the CAD sheet?
Yes, sir.
Okay, in the CAD sheet. Okay, thank you.
So
Thank you.
that being, notwithstanding that they call him back, they still ask, can you identify yourself? And he still refuses to do it, right?
He does that.
Even after they've called him back, when they allegedly know who he is,
Correct.
they still ask, who are you? And he says, I don't want to give my information. And he refuses to identify himself.
True.
So coming back to the two guys coming out of the door, the black hood and the red hood are now coming out of the door. Are they coming out of the door with the police asking them to step out? I saw a video, and I'm trying to figure out where in this stream is that video taking place. I see the black hood and the red hood come out of what appears to me to be a side door of a Nike store.
Correct.
And they're having some conversation with the police officers. And at the same time, I see your client, it appears to me, go out another door.
That's right.
All right. So as he's going out the other door, they've now got the red hood and a black hood detained,
Right.
right?
Correct.
All right. So go ahead.
Well, I mean, I thought that would have dispelled the inquiry, and to go after, now they got to do issues of cooperation as far as I understand the law, and if they did that, at that point, at the point they stopped Red Hoodie and the guy in quote-unquote black hood, I would think any suspicion that they had would have been dispelled. They choose to go, Officer Kearney chooses to go after my client and pursue him.
There's another black male with a black hood.
Right. So now we're just chasing black men with black hoodies on all around the city where there's 50 to 150.
Well, Kearney does testify that when he re-enters the store, the defendant is intently or vigilantly monitoring, looking at him. And then as soon as Kearney goes by, he gets up and walks in the opposite direction to leave.
I know he testified to that. Is that in and of itself?
No, it's a factor.
It's a factor. But again, how much weight does the court give that factor?
Well, but then when he sees him walking away, he notices what he believes, based on his training and experience, to be a firearm in the pocket.
And where is he when that happens? Where is Mr. Bowman when that happens?
When Officer Kearney claims to have seen the weighted front pocket,
yes.
I believe he was walking out the door. He was already out the door at that point.
So he's outside the building.
Yeah, he was
walking
on his
away
way,
from the
walking away.
Right. We had my chambers, I had technical difficulties, not surprising. I'm wondering, we couldn't play 2 of the 3 videos that were sent to us. And I'm wondering if any of the videos capture this weighted object in his pouch.
I did not see a weighted object, quite personally. And on any of the videos,
okay.
I'm sure my sister will say, yeah, it was right there, but
I didn't see it either.
Yeah.
And I saw all 3 videos.
Okay.
Right.
Okay.
And I didn't see it. But what I do see is he asked your client, while he's got the other 2 guys detained, he asked another officer who's followed your client out a different door, asks him, who's walking away, hey, my man, can I talk to you for a minute?
that is true.
Your client turns around to speak to him, it appears to me. He stops and turns around to address him. And I can't see the pouch or the front of his sweatshirt at that point. I just see the officer then go up and say, you don't have anything here. I hear what the officer says, but I don't see what actually takes place there.
Well, at that point, I think the court, that being the lower court, the grabbing of the arm was the seizure, and that was the definitive point in which these constitutional protections kicked in. So it would be at that point that we look at this as a unreasonable stop. So that's what at least Judge Key found in the lower court.
Judge Key credited Kearney's testimony, right?
Yes.
Yeah.
At no point did he
And Kearney testified that he saw the gun, or what he believed to be a gun, in the pocket.
I did not see that in the opinion.
Well, he testifies whatever that was in the front pouch was heavier than
Was
a
heavy.
wallet or just keys.
Well,
I thought
He did credit that. I mean, but to say it was a gun, I don't think that he made that finding.
So Judge Key makes the justification for all of this, the reasonable suspicion of what? Reasonable suspicion of an armed robbery. So my question, which I didn't see in the briefing, is, okay, reasonable suspicion of an armed robbery. First of all, everybody's wearing masks, and it's interesting. The first video I saw, everybody, including the police officers, are wearing masks. I thought that was quite amusing. So masks in this context, October 2021, in a public place, seem like a nothing. But the question that I thought was sort of interesting, armed robbery, but he's stopped after he's walked out of the establishment. There's not going to be an armed robbery no matter what because he's leaving. Does that matter? I don't know the answer to that.
Does the fact that he stopped after he's already left the premises?
Yeah, the basis for the stop.
I think it does matter.
Reasonable suspicion of an armed robbery. That's the base. It's got to be reasonable suspicion of a crime. And the crime here, the judge inserts, is armed robbery. And he's leaving the place. So that's my question. Can they stop him after the suspected crime is dispelled?
And my answer to that, quite frankly, is no. Everything about an armed robbery, once he leaves the store.
You have a case for that?
I don't have one off the top of my head. I think I could brief that. But again, what evidence that was there of an armed robbery to begin with? I mean, I didn't see that in any of the transcript or any of the record that we have in front of us.
Well, I mean, you know, the Commonwealth's going to say, if the tip is not nothing, if it's something more than nothing, you have a suspicion of one guy handing another guy a gun, and they're wearing masks, and they go into a commercial establishment. I mean, if that's all true, and it's not COVID and everybody's wearing a mask, that seems like reasonable suspicion that an armed robbery might be about to happen. So it's not crazy that the police officers show up, but it's more difficult once he's left.
Exactly. I guess that's more of my point.
Okay.
And in the context in which this happens, which it was the midst of COVID, everyone having a mask is...
That may be true. Nevertheless, it's still an identifying factor, perhaps, that these two people had masks as they entered the store. And arguably, it's not something you see every day, somebody passing a gun as they go into a store at 2:53 in the afternoon. That aside, the 911 caller said a surgical mask, is that right?
I believe he said surgical mask.
Right. Did Mr. Bowman have a surgical mask on?
From what I understood, Mr. Bowman had a mask that was half over his face.
Was it a surgical mask?
I don't think it was a surgical mask.
Okay. I have nothing else.
All right, thank you. Ms.
Thank
Hartley.
you. Your Honor, just briefly, I did have Morales that I did not include in the brief.
We know it.
Good morning, and may it please the Court. Brooke Hartley for the Commonwealth, and with me at council table is the motion to suppress Prosecutor Amanda Corin. This Court should affirm the denial of the defendant's motion to suppress. There was reasonable suspicion in this case that the defendant was committing the crime of carrying an unlicensed firearm or about to commit the crime of armed robbery.
We know he's been described, the caller says they're between 16 and 20, right?
16 and 18, the caller says. Once the officers are on scene, the officer testifies that he thought between 18 and 20.
Can someone that age be properly licensed to carry?
16 and 18, no. I did not include that as a factor in the officer's, in the reasonable suspicion analysis, because once the officer gets them, he doesn't exactly confirm that detail. His testimony is a little different, 18 to 20.
Right, wait, sorry, but when? And what's the basis? I think you jumped to the end, in my mind anyway. At what point do the officers have reasonable suspicion to believe? I get your point, that anybody under 21, that if they're holding a gun, it's illegal, period. Got it.
Is that true?
Yes, Your Honor.
20, no good.
I believe so, Your Honor. I believe it, yes, yes.
Okay, and, okay, so at what point did they have that reasonable suspicion?
At what point did they have the reasonable suspicion? So
Right.
the reasonable suspicion is based on 5 factors in the Commonwealth's opinion.
At what point did they have it?
What point do they have the reasonable suspicion?
Yes.
Right before the stop. After I think it doesn't, he doesn't have the reasonable suspicion until after he goes in, comes back out. Well, first he goes in, he corroborates what he hears from the 911 caller. Then he comes back out, goes back in again. At this point is when he sees the defendant in the black hooded sweatshirt sitting, watching him vigilantly.
Did he have reasonable suspicion to stop the red hooded sweatshirt and the gray sweatshirt with the black hood?
Well, that's not an issue in this case, Your Honor.
Did he have reasonable suspicion to stop them?
I think that's an entirely different question.
That's the question I'm asking you.
Yes, I understand. Different factors, because he doesn't have the firearm weighing down in his pocket, but I would argue yes, probably, given the fact that I can go through the caller and why it is that there's significant basis of knowledge and reliability, but the fact that he
I'm just trying to figure out how particularized is the tip if we're stopping what appears to be black men with black hoods.
So I think the tip is, first of all, the judge found basis of knowledge based on the fact that he saw it firsthand. Second, going to the veracity prong, I think it's important that.
Wait, what did he see firsthand? I think he saw innocent, well, I'm not sure what you're talking about, but chronology is important. But initially, going into the store, he sees a black man or young man in a red hoodie. He sees a black man in a gray with black hoodie, I guess, together. Those are, I think, innocent details in our case law. So the basis of knowledge for innocent details. He doesn't see for basis, the real meat and potatoes of this basis of knowledge would be a gun. He doesn't see a gun.
No, Your Honor. The caller?
Yeah.
No, he does.
No, sorry. The police officer corroborating the tip.
So I'll start with the caller. What the caller saw is he says, I saw one guy pass a gun to another guy. He describes them in significant detail. Red hooded sweatshirt, black hooded sweatshirt, describes about their age, black males, about their height. When the officer arrives, he goes into the store, and what he first sees is the male with the red sweatshirt hoodie and black sweatshirt hoodie at the cash register together.
Right. So are those innocent details? What's significant about those?
So at this point, perhaps innocent details, but that's not all. He then leaves, and once he enters again, at this point the red hooded sweatshirt is outside, but once he enters again, black hooded sweatshirt is sitting on the bench. That's when he observes that he's being hypervigilant, he's watching him.
Right, and on that point, there's a video, the first video, of when the red hooded sweatshirt fellow is standing inside the store and the police are talking to him. You can see outside in the store in the background several people, customers, walking back and forth. And every single customer that's walking back and forth is, I guess, vigilant, I don't know about hypervigilant, of this exchange. And it's obvious in common sense why. They're like, ooh, there's a police officer, there's 4 police officers, and they got that guy up against the wall, and they're looking at him. They all seem hypervigilant to me. And I think we know that there's 15 to 20 police officers in this establishment, which is kind of unusual. So in other words, this incriminating point that he's watching police officers walk back and forth seems to me, I'm struggling to understand why that's significant.
Sure. By itself, not significant,
Right.
Your Honor. Not enough. In the
Right.
totality of the circumstances analysis, I think it's one factor that contributes to reasonable suspicion here. Not only do we have the fact that he's watching the officer, this hypervigilance, but then we have the fact that officer walks past him, he gets up with a group of other companions, and they start to walk in one direction.
Not red hoodie, by the way, right?
No, red hooded is
Right.
not there.
Right.
He then reverses direction, goes in the opposite direction of not only his companions, but the opposite direction of where most of the officers are congregated. So I think this, again, by itself, even this evasive behavior would not be enough, but I think when considered in the totality of the circumstances here, it's one factor. Then the next factor you have is officer follows him, and that's when he observes this weighted object in his sweatshirt, which I think is the corroboration of a non-innocent detail that Justice Desmond was asking about. That's the corroboration of the fact that this caller called and said, I saw red hooded sweatshirt hand a gun to black hooded sweatshirt.
Right. Is there any, sorry, go ahead.
He
Go
also
ahead.
said that he put it in his pocket.
He says the exact language was, Yeah, he said he put it in his pocket after he received it. Yeah, that's
Wait,
in
sorry,
the judge's
who-
findings page.
I'm sorry, who
44
put,
of the
who
record
put,
appendix.
sorry, I didn't, who put,
Black hooded sweatshirt, put it in his pocket.
That's the exact language?
That's the judge's findings. I don't have the transcript site right here. I can certainly go back and send that to the court, but the judge found that the caller said it was put in his pocket.
oh, sorry, the collar. You're talking about the collar. Right,
Yes.
sorry.
So
sorry.
that's the non-innocent
Yeah.
corroboration.
Not necessarily his front pouch.
He didn't, I don't think he said front pouch, he just pocket.
And it was interesting to me, the officer very clearly testified that as he approached, as he watched Mr. Bowman leave the store, he had his hands down at his sides.
Yes.
And not in his pouch of his pocket. And that seemed to me interesting.
Sure, I don't think, certainly one more factor would be helpful to the Commonwealth if we had that, holding the waistband, adjusting the waistband. But also this is different than a gun in the waistband. This is a gun in the front pouch. It's not necessarily not secure and going to fall, which is typically why officers testify that they in their training experience, often suspect a firearm when someone is grabbing at their waistband. So I think in and of itself, each and every one of these factors would not be enough, but when you put them together, the totality is enough.
Backing up on, one of those factors you signified or highlighted was that Mr. Bowman he went out a different door and went in a different direction than where his apparent companions, including the fellow in the red hoodie, were at the other door. There were a whole bunch of police officers in that area, right? And so he's also, you might also say he's simply choosing not to walk through a phalanx of Boston police officers and walking away from that phalanx of Boston police officers. Is that a fair reading of what he did?
I think that would be one innocent explanation of what he did. But again, the officer, in terms of evaluating reasonable suspicion, isn't required to credit these possible innocent explanations.
So had there been 5 young black males with hoods on, with something heavy in their front pocket, would the officer have been within reason to stop all of them and check their pockets?
I think that would be a different case. I think part of what makes this significant here, in part, is that there is testimony that these were the only 2 out of 50 to 100
But we know that's not true, because we've already stopped another guy who's got a black hood on with the guy with the red sweatshirt. We have them detained while we're stopping Bowman. So there's at least 2, right?
Well, he's not wearing a full black hooded sweatshirt with jeans with the collar.
Why'd they stop him?
Because I'm not sure that they frisk him. He's with the gentleman in the red sweatshirt, walks out of the store with him. I would also note that
That's enough to stop him, because he's with the guy with the red hood?
I'm not sure he was stopped, Your Honor. He comes out of the store, he has some conversation with the officers, and no, I don't know that that's enough to stop him.
At some point, we see them at the front of the store, and the police, he's saying, "Why are you stopping me? Why me?" He's saying, "I'm stopped." And they're saying, "Hold on, just bear with us." And he's saying, "Talk to me, officer." So clearly that's a stop, right?
So I think I'm not sure that I would say that it was a stop. I think he's asking, why are you talking to me? They asked him for his ID. They said it's because he's
Did you get the impression that he was free to leave?
I think he was free to leave. He said to the officer, "Here's my ID. I'm not going to give it to you, but I'll show it to you." He said, "Fair enough." So either way, I don't think it has any impact on whether there was reasonable suspicion to stop the defendant in this case. I would also note, as the court pointed to, as my brother was giving his argument, I think the fact that the gentleman in the red sweatshirt comes out with his hands up is another factor to consider. I don't know that we can say it was unsolicited, because I'm not sure what happened in the store before, but the fact that he puts his hands up, one reading of that would be akin to Sweeting Bailey, where you have, which is not cited in my brief, but since the panel brought it up, would be that you have this individual who the caller had reported, handed a gun to someone else, coming out as a distraction. "Hey, look, I don't have a gun. Don't pay attention to my buddy in there who I just handed the gun to, who is in his front pocket." So I think that could be one more factor in the list. I would also like to just go back to the question about the reliability of the caller. So I know Your Honor is intimately familiar with this issue from Morales, and I think this is distinguishable from Morales. And I would first highlight Costa. And I think the legal reasoning in Costa is very important here and sort of colors this entire discussion. Costa says that it's important to recognize that citizens who report criminal activity justifiably may be concerned for their own safety if their identity becomes known to persons subsequently investigated or arrested. Costa goes on to say, this circumstance should not stand as an insurmountable impediment to a favorable assessment of the reliability in cases such as the one before us. I think that's very important here.
I get it. I mean, I think the police did what we want police to do. They responded to the Nike store. They assessed it, didn't see anything amiss. They spoke with the store personnel who said there doesn't seem to be anything amiss. They didn't stop anybody. They didn't pat anybody down. They went back outside the store. At that point, I think that's what we want police to do, to investigate. It seems unusual. Somebody's passing a gun going into a Nike store at 2:55 in the afternoon. It's the stopping of multiple people. Do you have reasonable suspicion to stop multiple young black men with hoods on? That's the question.
So I think the answer is there was reasonable suspicion to stop the defendant in the black hooded sweatshirt and his companion in the red hooded sweatshirt. I would also note, just in terms of the reliability, I disagree with defense counsel. The call back did include information about the gun. So if you look at page 46 of the defendant's appendix, that's the 911 call transcript. The caller repeated when called back that he saw a gun exchange between these two men, and he again gave a specific description of them. Now, that's not clear from the
He said it was a black gun.
He said it was a black pistol. Yes, and so that is what distinguishes this case from Morales. And then the non-innocent corroboration of him seeing that heavy sweatshirt pocket. We don't have that in Morales. And I think I would note the officer likely wasn't aware of at what point they received that information, but I don't think that matters. The question is reliability. It's an objective standard of reasonableness here. So I think that is what distinguishes it from Your Honor's recent opinion in Morales. Unless the court has further questions, I would rest on my brief.
Thank you.
Thank you, Your Honor.
Very well done. Thank you. We're going to take a short break.
Put all rise, please. Court is open. Please be seated.
Our next case is 25P 450 METCALFE versus Arbella Mutual Insurance. Mr. Eisenberg.
Good morning. Good morning. May it please the Court, Louis Eisenberg on behalf of Arbella Mutual Insurance Company. This is a coverage question regarding two policies that Arbella had written. The background here is that in Hampden Superior Court, a Ludlow police detective was injured making an arrest with a Stephen Martin. A lawsuit was brought by her. Mr. Martin proceeded pro se and eventually agreed to a judgment of $300,000. He was by himself. He was not involved with Arbella at that point. Shortly later,
I just asked you a question outside the record. When he agrees to the $300,000, is that a pro se decision?
It was, apparently. He had no family member. He appeared in court. He answered the complaint.
That happens to be the maximum on the policy, right?
Correct.
Did he know that? How would he know that? I mean, I don't understand how he's making that decision on that.
I don't know. I can't answer that. I'm sorry. The second suit was then brought by ALISON METCALFE against Arbella. The Martin family had no involvement in that case whatsoever other than being subpoenaed to come into court. In that particular suit, it went to a hearing before the court without a jury. The Honorable Karen Goldenberg made her decision the end of last year. The lawsuit that's been brought here is there's in this particular case, there are two insurance policies in issue here. The first is a Ludlow policy, which was a dwelling policy, and that particular policy required that incidents occur on the premises.
Can I interrupt? Which policy did the judge say controlled here?
Well, the decision is a little bit confusing to me. The judge said that we all agree. I think the judge did say that everyone appeared to agree, and it was stipulated that the Ludlow policy, that was the policy that the Martin family lived in, had no coverage.
Because the occurrence or the event would have had to occur at the Ludlow house.
That's correct.
Which did not occur here. So it's only the East Long Meadow policy that's really in play.
That's correct. And on the lawsuit, the claim was declaratory relief, reach and apply, counts 1 and 2 for Ludlow, counts 3 and 4 after an amendment was made for the Long Meadow property. It would have been easier, Judge, if the decision said, I fine for the defendants on count 1 and 2, and I fine for the plaintiff on counts 3 and 4. But I really don't think that that is actually an issue. So the question in this case really...
So the East Long Meadow property,
yes,
that insurance covers, at least, I think, household residents.
it does. It means
Go beyond that?
It means you and residents of your household who are related to you.
Does it go beyond that?
I'm sorry?
Does it go beyond that?
No, well, it goes beyond it in the sense that if someone is an insured on the policy, beyond that, for this case, there would not be any issue of household member because Mrs. Martin lived alone, Elizabeth Martin. Lived there by herself.
So the only insureds are household residents. Is that right? With respect to the East Long Meadow property?
Yes.
The only insureds would be the household residents.
It would be the named insured and any member of you and residents of your household who are your relatives. They would all, by definition, they would also be covered.
Got it.
So going forward on that issue in the complaint, there were 4 witnesses in the case. The first was the police officer who didn't offer anything about the relationship of residents. But then Elizabeth Martin testified. She had bought this house in 1998 in Ludlow. Wilford, her son, lived there. He did pay rent in the beginning until a year or so before this incident.
I'm going to interrupt you again. How do you define household resident?
Well, under the cases, it's a case-by-case method, and under the Villarreal case, there are 5 factors that are set out that can define whether or not someone is a household member.
Can I ask you about that? Doesn't the policy have to be ambiguous as to what household member means before you retreat to the factors?
No, I don't believe so. I think what the court has said is that these really aren't not ambiguous, but these are the factors that through case law has basically been decided.
But the East Long Meadow policy says the insured is not defined by member of household. It's defined by resident.
It's defined as household members are residents of that
Which
house.
doesn't seem ambiguous to me.
You
Doesn't seem ambiguous to me.
I agree, but I think the factors then have to be decided who is a household member. And that's where the Viella case has...
Still would have to be a pool of people who reside there.
That's the question. Household member is not necessarily a household resident, or is it?
Well, I think
Member
it-
is not resident. They use those two words.
Well, I think that's
Particularly.
specifically, that is the issue, Judge Desmond, here, because when the judge makes a decision that the East Long Meadow property is the property that will pay the judgment on behalf of Stephen Martin was never a resident of that household
Get it. So that's
at
what I'm-
any time. And when she made the
Not
finding...
at any time, but not for a long time.
Yes, so we know that there's none of those 5 factors apply regarding East Long Meadow with Stephen Martin. The one factor that the court found relevant was financial. And the financial connection to the Ludlow property was that rent was not being paid and that the grandmother basically was taking care of the property.
Can you be a household member and not a household resident?
No, I don't believe so. I think you have to be part of the household and then you become, if you're a resident of that household and you're related, you would be covered. In this particular case, Stephen Martin was never a household member with Elizabeth Martin at the East Long Meadow property. The judge made the finding as if she's talking about Ludlow and said financially, there's a factor here that applies. And that factor here is the fact that she was paying basically the rent, so to speak. That was only one of 5 factors, but even on that, we take issue in the brief on the first argument that we think the court made a mistake there because she gave him no money.
But she paid,
housing.
yeah. The
sorry?
judge relies on the fact that the grandmother paid for the housing in the Ludlow home where he lived at least 50% of the time, right?
That's correct. And we don't-
So you're saying that that's not financial assistance?
Well, it is financial assistance, but
So why, the judge
well, the
almost
whole-
based the whole decision on that.
That's correct. And of the 5 factors, I think we can agree that the other 4 have no bearing whatsoever.
I don't know. He gets his mail there, right?
He
in
gets,
Ludlow.
yes, he gets his
Yeah.
mail there, right.
They're Ludlow,
Not
not
East
East
Long
Long
Meadow.
Meadow.
Yeah.
That's correct.
Right, and so the
Right.
policy coverage must be the East Long Meadow policy.
Absolutely.
So he must be a resident of East Long Meadow.
Exactly right.
And so getting his mail at Ludlow is no help to him.
I agree with you, Your Honor.
got
And I
it.
think that issue was, she made a decision as if she's finding, okay, if we're talking about Ludlow, yes, not because we necessarily agree that the financial part was sufficient. In fact, one of the cases we cited, there was really no relationship at all, other than the father was paying the tuition of the son. And in that particular case, that still wasn't sufficient.
So the Morell case that Justice Goldenberg cites is a little interesting to me. Maybe you could speak about that. But that at least, I mean, there's a lot of differences, I think. But the father, to Justice Meade's point, resident of the household, it seems unambiguous. It seems simple, but here we are with an insurance company and a contract. But the interesting point is, at one level, the father doesn't actually live primarily in the house that the son lives in, and then the horribleness happens, the son is in the car crash. But it's a different kind of policy. That's an excess liability policy?
Yes.
Is that a material distinction?
I don't believe it is, because the court says what we really come down to is residence, the household. That, I think, is the key case, because the court
Morell,
cited it.
you mean?
Morell.
Okay.
And my brother cites it for the proposition that just because you're a household member of East Ludlow, that automatically makes you a household resident of East Long Meadow. That is inaccurate because I don't think that's the law. I found no case that said that. In fact, I think Morrell is helpful on that for this reason, Judge. Morrell was an excess policy where the son drove the car, caused a bad accident. The argument was that the father lived in Hubbardstown in an apartment. The son, did not live there. The other property was owned by his, not ex-wife, because they were still married, but there was real estate taxes paid. He had a strong connection.
It was the marital home originally.
It was.
Right.
And there was a strong connection between the father and that property, which was Cottage Street, and I forgot what town that was. The bottom line there was the court said that the son gets coverage because he's a resident there and he's a member of the household because they found that that is a household that the father lived at. Case law has said you can be living at more than one house, and that's exactly was that arrangement. But that court did not say that the son would have coverage in the father's apartment. Right. And if you read my brother's brief, their argument is that Morrell stands for the proposition that, on the Morrell case, that the son would have coverage under the father's policy. That's not what the court said. If we transpose that to our case, Stephen Martin lived in Ludlow some percentage of the time. He was a resident there when the incident occurred. But he was never living at the other property, which is the East Long Meadow. How does he become a household member of East Long Meadow when he had no connection whatsoever to the property? The court never analyzed that issue directly.
If he's a household member, if one were to conclude that he was a household member but not a resident of East Long Meadow, is he covered?
If he's not a resident, but he's a household member?
Yes.
I don't see how he could. There has to be that connection. It's easy to say, well, if you're a household member at this property, you're automatically there. No, because those policies are based upon what particular property are we talking about. And I think that the judge never got to that issue on that question of, well, what about East Long Meadow? She just made a finding, in essence, really, that she believed he was a resident, household member, but it was the Ludlow property and there was no coverage there.
I'm sorry. On the financial support issue, the SJC seems to add an added wrinkle to it is whether or not, in this case, Ms. Martin had a legal responsibility to provide for her grandson.
Right, which she didn't. She did not because he was fully emancipated. Right. In fact, he testified at trial. He was dependent upon his parents.
And theft.
And I was just going to say that unfortunately he had a drug habit and he was supporting himself in that way. So the fact that there has been some rent paid, we don't dispute that, but that had never been the case from the beginning. In fact, she was getting rent as if it was a landlord-tenant relationship.
Who paid her rent? Her son, not the grandson.
Nobody was paying rent for the 2 years leading up to the event. Right. She was paying for the house in the sense of real estate taxes, insurance, and water and sewer.
I mean, it's fair. Sorry, go ahead. Go ahead.
She wasn't even looking for rent from them, right?
I didn't hear you, I'm sorry.
She wasn't even looking for rent from them. They'd pay sometimes, they didn't pay. When they didn't pay, she didn't ask for it. She wasn't keeping a ledger how much was outstanding. She wasn't interested.
So it's fair to say that she was, in fact, supporting all of them in the sense of giving all of them a roof over their heads, the single biggest expense most of us have. But your point, I think, is that's, okay, fair, accepting that that's not enough.
Yes, and I wouldn't say that she is supporting them because the only thing she's doing is covering the expenses. No, but
sloppy word, but she's providing housing for them. Right.
And one of the cases in particular that talked about, well, the father was paying tuition for the son, but there was no household member determination that was favorable to the plaintiff in that case. Okay, well, is that different than this? Paying the tuition of the son going to college, who was autonomous otherwise, that's our case. And the court said, well, that's simply not going to be enough. So I think on balance here, the decision, I think, was inartfully drawn in the sense that the court did not focus on what about East Long Meadow, and is he a resident household member there? So our position is getting simply looking first at the issue of, well, what are the factors and is it strong enough? But that would really only affect East Long Meadow, Ludlow, for which we're not here, but we're talking about East Long Meadow.
You agree that she purchased the Ludlow home specifically so that the family would not be homeless?
Yes. That's exactly why she did it. And in the beginning, I believe he was working, he became ill, and then...
the father.
I'm sorry, Martin Sr., the father. He was ill, couldn't support the family. His wife's family was helping. They were paying some of the expenses themselves, et cetera. So I think basically that our argument is that there is no coverage for East Long Meadow.
We're going to have to leave it there.
Okay?
Thank you.
Thank you.
Mr. Ballin.
Morning, Your Honors. May it please the Court, Attorney Zachary Ballin here for the appellee, ALISON METCALFE. This case, I think, presents when we look at the case law around it, the standard that we need to look at the court's findings with is the clearly erroneous standard.
Why is that? I saw you wrote that, and you wrote it after a whole bunch of case law on interpretations of contract and definitions is a question of law de novo. And then at the very end you said, without a case, as far as I could see, but this should be clearly erroneous factual finding.
Well, I think there's a number of cases that lay that out. And first of all, this court used the very same analysis for the very same verbiage in the Vermont Mutual versus Stevens case.
Is that published or unpublished?
That's an unpublished opinion.
Okay.
So what's your best published case for the standard of review?
I think first the Lake Ridge case from the Supreme Court sets out that this is at best a mixed question of fact and law.
The SJC has said it's not a mixed question.
Well, first that case came out after the Viarella case, so that would be an issue.
The Supreme Court case, that's not an insurance case. That's just a mixed question of law definition.
But I think it's an instructive case where you're looking at this question of, well, what is the legal standard to apply? And then if you have a clear legal standard, then you get down to a factual analysis of how
Let me put it another way. So the standard does not involve a question of federal law, right?
Correct.
So we have to do what the SJC says.
Okay.
Which is it's a question of law.
Well, so first and foremost, what I would say is both parties have agreed in their briefs that the clearly erroneous standard is applicable to this case. Certainly, there's been a bench finding here.
Well, this is stipulated facts, right?
There's a stipulated fact as to that Stephen Martin was a resident of the Ludlow property.
There was pages of stipulated. The judge didn't
there
take
are.
evidence. It's a stipulated fact trial, right?
No, there was absolutely testimony from 4 witnesses at the trial.
Okay.
There was testimony that was impeached. There was testimony from Elizabeth Martin that was impeached as to the question of her intent in purchasing the insurance policies. So there was significant testimony at trial.
So I have 2 questions. One is, there's a stipulation that Stephen Martin Jr. is a resident of the Ludlow property.
Yes.
That doesn't sink you? Doesn't
No.
he have to be a resident and a household member of the East Long Meadow property?
He has to be a resident. First of all, I think the operative word here, he has to be a resident of the household, a household resident of the East Long Meadow property.
Right, but you just told me you stipulated that he's a resident of the Ludlow. He can't be a resident of both, or can he?
I think maybe I would more accurately say that we stipulated that he qualifies as a resident of the Ludlow property, that was not an issue that was in dispute in the case. But what I would say is that the question of whether or not someone is a resident of a household is very different than the question of do they physically sleep in the building.
But the East Long Meadow policy doesn't define insured as member of the household. It defines them as resident.
Which is the exact same language that was analyzed in the Morrell case and in the Stevens case and in a number of these other cases where the court looked to, I think the Morrell case is instructive on this point as it regards to that term. What the court said.
Do you agree that the only Virella factor that's in play here is the financial support?
I do. That's a critical factor, yes.
And in Virella, the SJC said that that's weakened when it involves relatives when there's no legal responsibility to provide. Do you agree that she had no legal responsibility to pay his rent at the Ludlow house?
I do, yes.
So you've got, what you left is financial support, beneficence really, by the grandmother for her family and grandson that she has no legal responsibility to do.
Absolutely correct.
So that alone is enough to, that one weakened factor in the face of no other factor applying is enough to overcome the problem here you have.
That is what the trial court judge found.
Yes, I know. And it's here on appeal.
I do believe it's supported by the evidence. I do not believe that finding was clearly erroneous. May I address those questions?
I don't think anyone is disputing that she bought and paid or took care, or didn't receive rent, bought the house to take care of her family so that they wouldn't be homeless.
Yes.
What I'm saying is that's all you have.
Yes.
And that it's weakened by the fact that she had no legal responsibility to do any of that.
I'm not disputing that, Your Honor. May I go on?
Yes, go ahead.
Okay. So in the Morrell case, where they're addressing this exact same language, resident of your household, what they said is, hey, this is not the auto context. The insurer wrote this contract. If they wanted this to specifically say resident of your household means someone that sleeps at this address that we wrote down right here, they could have written that.
Can't we just rely on plain old English?
If it were so simple, we would have less work to do, I suppose. But
So it's fair to look at and see what the Merriam definition of resident is.
I think that the courts have clearly been analyzing this question repeatedly and found that it is not clear in the language of these policies.
Right, but so in Morrell, the dad didn't actually lay his head down at the same place where his son did, the Cottage Street house. So there's one fact, right? That's right. And yet the son was deemed to be a resident of the dad's household in the excess liability policy.
It's the word household here, which is the piece that's so interesting, because plenty of other states have found the exact opposite conclusion, which I think is kind of what Justice Desmond was getting at. Hey, you don't sleep there. And that's what other states have concluded. Resident of a household this is four walls.
Right, but then we go on. Sure. I get that concept. It's fuzzier. But the problem for you, it seems like in Morrell at least, if that's what your best case, that the dad has all sorts of connections. That was the marital house, and he has all sorts of he's got the keys, and he gets his mail there, and he's there every single week. And so the court, at least, found that all of those factors in that case were crucial to a determination that the son was a resident of his household, and that the father very intentionally wanted the son to be protected by that excess liability policy.
But in Morrell, the court also wrote that father retained significant financial responsibility for his wife and sons. They lived in a dwelling of which he was co-owner, and he continued to purchase insurance for their benefit. Michael, the son, was not financially autonomous. He did not pay rent or contribute to household expenses. His financial straits were such that his own motor vehicle had been repossessed. Virella, Morrell, Lang, Stevens, yes, they look at these factors, but financial dependence is like a trump card in these cases. It comes in huge. And if we think about, here's the question that the courts have been wrestling with. It's the word household, Your Honors, I would submit to you, that becomes the operative word here. Because household is not a house. It's a critical thing. This week, when we have sub 10-degree temperatures, you really start to think about, and it's hard not to think about my own kids, and you think, what does that mean to leave someone homeless on the streets?
Mr. Eisenberg gave us a dictionary definition of household as those who dwell under the same roof and compose a family or social unit composed of those living together in the same dwelling.
And that's not a definition that's been accepted by the court in this state as the definitive and dispositive ruling. And if Arbella wanted that to be the definition, they could have written it. But
I don't disagree with that, but aren't these are standard forms, right?
They're standard forms, but there is a process by which they can edit it. And this is if I may.
I would, if I would have my druthers, they could write their policies in English. It would make us all happy.
The Morrell Court, reviewing this exact same language, resident of your household, said specifically, we're outside the auto context, and yet the other party is entitled to a more generous construction of the term, because the insurer here had the ability, outside that auto context, to draft the policy. So household had but one definition.
But what about resident, though? I mean, are we supposed to be, how do we take a definite term and then construe it against the insurance company, despite the fact that we all know what a resident means?
I don't want to, may I?
Please.
I think
standard of review is key for me. So
I'm sorry?
Standard of review is key. So you're relying on language as your best case? That's what I asked, so I understand what your best case for standard of review.
Okay. Context, I think, is critical in what words mean. And I'm sure there's a million examples of that in life, right? You can say one thing in one context and it means one thing, and one thing in another context and it means something totally different. These cases are certainly well known to Arbella when they're pursuing their business and crafting their contracts and deciding what to change and what not to change and what changes to pursue or not. Look, I think if you look at the Vermont Mutual versus Stevens case, the court lays out in that case, right, the standard of review is clearly erroneous. When we look at disputes involving residence requirements, they're usually regarded as questions of fact. And the reason why that becomes this clearly erroneous issue is because as the court wrote in Lake Ridge, right, what does the question boil down to here? The question that this boils down to is providing a house, right, which is, as Justice Wood kind of pointed out, 75, 80% of 90% of, I mean, you don't need internet, despite what people think, right? This guy didn't have a car. He's living on, he's a drug addict. He's some food and some clothing, but all the maintenance on a house, the house, the insurance.
Big. I get it. It's big. But sorry, the circling back, I think you guys already said this, but Morrell involved the term resident of the household, right? They both involve resident of household.
Right.
Okay, so we are talking about the same term. Morrell is relevant in that sense. We're talking about the same contractual term, right? Okay, and you're sliding past the distinctions between Morrell. I hear what you're saying, that the son couldn't hold a job really steadily. He was basically a ward of his dad. But it was very different in many other ways. Dad had lots of connections to the house. That's what your opponent is pointing out. That here, the grandmother had no connections to the Ludlow house at all. And he, likewise, had no connections to her house.
So take the Lang case, right? The Lang case, you had an individual that bought a property and rented it to a tenant. The tenant just happened to be a family member, but there was a professional landlord-tenant relationship, and they were not deemed to be part of the same household in the legal sense. So if we flipped the counterfactual here, and we said, hey, Elizabeth Martin, beneficent grandmother, because she bakes and she brings over cookies and she shows up and they hang out with her, that's a normal family relationship. We don't define economic household by family members who are still close to each other and see each other Thanksgiving, Christmas, Hanukkah, whatever.
Yeah, but we do define it as you have to have the SJC in Varela defines it by contacts with the household.
It's a factor. But economic dependence has always been the dispositive factor in these cases. And what the justice...
I want to focus on something else. You've already made that point, and we don't have a lot of time. The two policies, nobody really talked about this, but I think they're actually helpful in illuminating. There's this fuzzy discussion of what she intended. I don't know why that's really important in a contract case, but she, the grandmother. But she provided this Ludlow policy as a dwelling policy for the family. Any liability that occurs, tortious conduct by the family at the Ludlow property. To me, integrating that with the East Longmeadow homeowners policy tells me one thing that seems important. She's protecting them in Ludlow. If they were protected, as you're claiming, by the East Longmeadow policy, that dwelling policy is completely unnecessary. They're already covered under the East Longmeadow policy.
It didn't cover them beyond the household.
Right, but it's unnecessarily repetitive. If My point is, East Longmeadow would cover them everywhere, including at Ludlow.
You could argue it was, first of all, she restricted it more than a lot of homeowners' policies are restricted by limiting it to that property, and you could argue that there's some logic there, but I see your point as far as there being a slight overlap there. I agree with that.
Can I ask you, I'm sorry.
No, I'm done. Thank you.
Was there evidence that explained the interplay of someone suffering from substance abuse disorder and interfamiliar relationships?
Well, I think that was exactly the point I wanted to get to. Is I think
Let's start with answering my question. Was there evidence at trial about substance abuse disorder and familiar relationships?
there was no expert testimony to anything of that nature.
Was there any evidence at all?
There was evidence about his life and that impact on him. And what I would submit to the court is that it is a reasonable inference for the fact finder, for her having looked in the eyes of these witnesses and heard from this whole family testifying.
She made a conclusion of fact about the nature of their relationship could be explained because of his substance abuse disorder. Did anyone argue that or assert that at trial?
It was absolutely discussed at trial, Your Honor. I think it's a reasonable inference from the evidence that the grandmother would have preferred a closer relationship to her grandson had he not been addicted to heroin. It's an epidemic in our country. And the kind of last point I wanted to make was, with this question of it being a question of fact, is once the court, this central question of household resident is so fact dependent. That's the point that I'm trying to make with the review standard. And that's what this court has done in Stevens and other cases because it's so fact dependent.
Hold on, I want to hear what he has to say. Go ahead, what?
That's it, sorry.
I'm sorry.
Yeah, I'm all set.
All right. Thank you.
Thank you, Your Honor.
Thank you both. The next case is 25P200 Bonanno versus City of Gloucester Zoning Board of Appeals. Mr. Furman.
May I begin?
Yes.
May it please the court, Matthew Furman on behalf of the appellant Alison Bonanno and Attorney Shapiro is at the table as well. I'd like to start with the two summary judgment errors we claim.
Yes. You can't appeal denials of summary judgment after trial.
Well, Your Honor, there are the two issues we've raised we contend under the law can be addressed by this panel.
Do you have a case that says so? Because there's legion that say otherwise.
Sure. Your Honor, the Lavoie case that we cite in our papers from the SJC in 2020 talks about
and they permitted an appeal, excuse me, they permitted an appeal of a denied motion for summary judgment after there'd been a trial.
No, but what they said is the underlying legal issues.
Well, then it was probably the same issue at trial. See, what summary judgment is named summary because it's supposed to be taken care of ahead of time. When you go past that into trial, whatever issues were left unresolved, disputed issues of material fact, are resolved at trial.
Well, Your Honor, at the very least, the question of density-based standing did not go to trial. That was not part of the issues that was tried. But
That's a different question.
It is.
Right. And so let's, first of all, on the driveway, the impact on your driveway, your client's driveway, that was a trial. That's your summary judgment argument. You're trying to relitigate the error at summary judgment about the driveway. Can we put that aside? You're talking about density, the density argument. Okay, so that, it seems to me, there was no trial on that, right?
There was no trial on that. In fact, it was reiterated during the trial that that issue was not to be tried. Here's where we say the error was in that issue not going to trial at summary judgment. Was we know under cases such as Shepard and Dwyer that further construction in an overcrowded neighborhood is a basis for standing as a density form of aggrievement. Just in October, the Klein decision from this court said that unique harm to an abutter cannot be understated. That's right in the decision, and it generally constitutes a basis for standing. So what we had here is as undisputed evidence, the factual predicate for that Shepard-Dwyer basis for standing. Statement of facts number 8, it's in the record, Appendix 322, that the street was full of undersized lots with homes on them. And you had an acknowledgement of that in the summary judgment decision. And then you had uncontested evidence from Mr. Bonanno of the individualized impact, evidence that was supposed to be considered in a light most favorable to Mr. Bonanno as the non-moving party.
I don't understand. I saw those cases, and I'm going to have to do more research, and I'm no expert on zoning. But it seems like the cases are all over the place. That one of the cardinal principles is generalized concerns are not enough for standing. And then we have density, and sometimes it's characterized as a generalized concern. The neighborhood's getting too crowded. And then sometimes it's characterized as, no, an individualized concern of density, and so you do have standing. Why? And there was evidence. The evidence in the summary judgment was this aerial photograph. And to my mind, and I'm not from Gloucester, and I'm not from that Winger Chic area, looking at the photo, it didn't look dense. It looked like a whole bunch of big houses with lawns. And there was this one plot that's the same size as all the other plots, and I know it's undersized by new zoning rules, but at the time, all the other lots are about the same size. It looks like the same size as the other lots. Why is that dense, and why is the judge wrong to say that's not a generalized concern?
Sure, Your Honor. I think there's 2 points worth making there, and I'll do the factual one first because that's where you finished up.
Sure.
It was undisputed at summary judgment that the minimum buildable lot size was 20,000 square feet.
But they were allowed to build that because it was a pre-existing. You don't get to litigate the prior history with the prior owner.
No, but each individual application is done on its merits, and it was shown in the bylaw that in order to get the benefit to build based on the pre-existing nonconformance, there needed to be a prior build. It's a redevelopment on it. This is the only lot that had been vacant throughout the relevant period. So it doesn't get the benefit of that provision.
I'm not understanding how that makes this dense. Building a house there would make this too dense.
Sure. Your Honor, and this I think speaks to the second issue, and when you're doing the research you talked about, I think the key cases to look at are 81 Spooner from the SJC and the O'Connell case, where they describe the abutter's deposition testimony that was found to be sufficient
right, 81
to
Spooner.
show an individualized form of the density-based aggrievement. Right. So you have an 81 Spooner discussion from the abutter about crowding, a big house being proposed on a small lot,
right.
Shutting off views, causing traffic, and the SJC said even if not versed in the terminology of zoning, that's sufficient for density-based injury. Follow up with O'Connell, where there was discussion about a loss of open space and a massive new structure imposing upon them. So the answer to your question is, if it's down at the end of the street, you can't complain about the density. But if you're in a abutter, your interest in it cannot be understated, as the Klein court said. So if you look in the record at the Bonanno deposition testimony that was put before the judge at summary judgment, it's pages 265 to 269 in the record. It talks about the increasing congestion, the blocking of the sunset and dunes, the loss of the natural lot next to them. It's an undisputed fact that this is their sole way to get in and out of their property.
Wait, well, that's the easement argument. That's blending density and easement, to my mind.
It's not blending, and I appreciate that it gets blended somewhat, but the fact that they're reliant on the subject lot for their access is an undisputed fact, and that speaks to how the density injury impacts them. So it's not, even more so than a lot that they're not reliant on to get over. This one impacts them in a more unique way than it does the generalized community.
So part of that discussion was about whether or not they could back right out of the driveway or whether or not they had to do a multi-point turn out of the driveway. Is that what you're speaking to?
There was some discussion of that at both summary judgment and at trial, but the broader point is...
So that's one of the considerations. And did I also read that things had lessened a bit since COVID or no?
Had things lessened a bit since COVID?
Yeah.
Well, I remember we were doing those depositions by Zoom with masks on, and I think, yes, he said in his deposition testimony that there was less traffic in the area at that time because of COVID. However, for purposes of assessing whether there was evidence of a particularized density-based injury, my point is simply that the facts on the ground, where the lots are, how they get in and out, is relevant to understanding his congestion phrase statement, which is, I would say, at least synonymous with what the fog testimony cited by the SJC in the Spooner decision and the abutters testimony in O'Connell. In addition, the claim on the merits here was a merger-based theory, which is inherently about density, because you're saying that...
Yeah, but that, I'm not interested in that argument.
Sure.
I think that argument is not compelling. So can we talk about the, I don't want to cut you off on density, but I want to talk about the easement as well.
Sure. Do you want to talk about the easement at summary judgment or as it proceeded to
No, at
trial?
trial.
Sure.
So at trial, it seems clear that there are several things seem clear, and that's the benefit of a trial. A car, a regular old car, can go down the driveway, make a three-point turn, and come back, and be always going out onto the road head first. And because of the triangle, you're not going to have an obstructed view. So even with the location, so that's not going to be a problem. Now we talk about boats, trailers with boats. So the guy who lives there, as far as I can tell, isn't one of these people with a trailer and a boat, is he? The resident of your client's, the Bonanno family member, he doesn't drive, right?
There was undisputed testimony about them having 5 different boats over the 50 years.
This is what I want to drill down to. If we're going to actually have all this litigation, the de minimis standard and the speculation standard, they seem really compelling to me. The guy who lives there doesn't drive, so they're not his boat, they're not his trailer. So the question is, why should these other people be prevented from building on their own property, which the building inspector has said is okay, which the ZBA has said is okay, which this trial judge has said is okay, because of the danger that some other people can't drive their boat trailer down this driveway? That seems bonkers to me.
Justice Wood, I'd like to answer that in multiple parts. Okay.
Let's start with the boat trailers.
Sure, the boat trailer. Stephen Bonanno is in the record. He's an adult with special needs. He does not personally drive. Also in the record is that he gets great satisfaction from using his boat that they've had throughout the years. So to the extent that somebody bringing it in for his benefit, that's how it is used. But there was evidence of other oversized vehicles going in and out. And I think the phrasing in your question leads into the legal argument we make about how this case was considered at trial, which is this Butler's-Michaels 2 decisions from Judge McHugh. This is not a traditional merits-based analysis of who satisfies the preponderance. The inquiry here is a gatekeeping function. Is there a plausible claim? Is there a credible claim
the case
of
law,
an
am I
injury?
wrong that the case law makes clear that the judge can, on standing, can consider whether this is a de minimis problem? The thing that gives you standing, it only gives you standing if it's not de minimis or speculative. Am I wrong about that?
There is discussion about de minimis and exception in the case law, absolutely, but the inquiry for the court on standing under Butler and Michaels is to look at the quantity and the quality of the evidence in 2 ways. One, what is the quantity? Is there a failure of proof, or is there actual proof in the record of this type of aggrievement? And second, what's the quality? Is it evidence that a reasonable person could rely on?
And if
the merits of the claim, and
Go ahead.
As much as they talk about de minimis and speculation, they talk about the merits of the claim not being relevant. It's whether it's a credible claim of harm.
As much as they talk about de minimis, sorry, that confused me. It sounds like that's another way to put that is de minimis is a criteria. If the quantity and quality of the evidence establishes that it is a problem, but then it's a de minimis problem, then you don't have standing. That's what I heard.
No, my point is that the cases say repeatedly that the ultimate results on the merits is not relevant to the analysis. You look at the quantum and the quality of the evidence. Is there enough for it to be a credible claim? Let me give you an example with respect to the non-passenger vehicles, okay?
Big box trucks.
Sure, big box trucks. Boat
How long is
trailers.
this driveway?
There's
not long.
There's a survey plan in the record. It goes.
All right, it's not, let me ask you
shared
this.
by the 4 lots that touch it.
I want to, this is important to me, so
Sure.
just hear my question. Let's say that trucks now can't, because of this building, can't safely go down this short driveway and make a 3-point turn, although it seems unclear to me whether that's true. But okay, let's say they can't make the 3-point turn and come out safely. What's the problem with these trucks parking at the end of the driveway and walking the stuff down the street, down the driveway? And why isn't that illustration that any problem here is de minimis?
There should be no reason that somebody would be forced to do that as the owner of the property. But let me talk about this, okay? That's putting a constraint on
So your
them.
client is being forced to suffer the indignity of having a big box truck carry the stuff down the driveway.
Or not be able to park his boat on his property anymore.
Or be able to
okay?
park his boat.
But the question is whether it's a credible claim. So let's talk about the non-passenger vehicles for a second. The boat trailer, Lehman Landscaping, the other service vehicles. The court's task here was to assess the claim. And if you look at paragraphs 48 and 49 of the findings of fact, it's in the addendum and the record, you'll see that they say, as a factual finding, Mr. Meade, who was the plaintiff's expert, opined that there would be visual obstruction for oversized vehicles. The next paragraph, Ms. Pike, the defendant's expert, opined that there would not be a visual impact for oversized.
That's if they're going backwards, right? That the oversized vehicles, that's if they're backing up.
And Ms. Pike even backed out in her Mini Cooper at the time when she was
okay,
there.
but because she wasn't a big box truck, I get it.
Right.
But your point is there would be visual impairment if the big box truck is backing out of the driveway.
And there was a disagreement between the experts. And instead of doing what Michaels says, which is using the defendant's expert to assess the reasonableness of the plaintiff's expert, that's right in Michaels, the lower court found, I credit Pike's testimony that there was no visual impact. That is an error of law.
All right,
Pike's testimony that she could see through the fence?
I'm sorry?
Is Pike's testimony that she could see through the fence?
The construction fencing? Yes, but Your Honor, but Gale is very clear that interference during construction with easement rights, which I think is what a credible claim of presented with, is sufficient to confer standing. That's the Gale decision from this court.
We're going to have to leave it there.
Okay, thank you, Your
Thank you.
Honor.
Thank you.
Mr. Loeb.
May it please the court. Jeffrey Loeb, accompanied by Chabeli Lopez on behalf of Joe and Gloria DiStefano. Justice Wood, your question intrigued me, so I went back to the record to try and get the distances. I don't have the record appendix page number, but if we look at Exhibit A to Judge Foster's trial decision, the front lots are 126 feet, and then the Bonanno lot is then behind
126 feet deep.
126 feet deep.
Yeah.
And
Got
then,
it.
and then back, and then if you look within the record appendix at RA 277, that may be it's not a picture, but that may be one of the plans that Your Honor was referring to, and it shows the layout of the development of that neighborhood.
I'll track that down. I get what you're saying. So can we start with density, the density argument?
Sure.
And assume that the case law does provide that density for an abutter is a basis for standing. Your opponent correctly points out there was no trial on this question. The judge at summary judgment dispensed with it. And I looked really hard at the judge's findings, and it seemed given our case law, that density can be a basis for standing, that there wasn't a compelling argument for disposing of this as summary judgment. What's your best argument that the judge properly dispensed with that at summary judgment?
I'm going to pick up on your use of the word compelling. There wasn't compelling evidence otherwise. When you look at, if you look at the summary judgment record, and you look specifically at Judge Foster's decision, and he distinguishes the two, as the panel did, there are two aspects to density. There's the neighborhood density along the street, and then there's the impact of the density on the easement. What he said as to the latter, yeah, we need a trial on that. But as to the neighborhood density, if you look at what Mr. Bonanno in fact said, and Judge Foster quotes it, well, there's this density, it's dense. That's not enough.
How is that distinguishable from 81 Spooner?
Because I would suggest that 81 Spooner is in the right case to be looking at anyway.
Well, okay,
No,
I don't like that answer.
No,
Tell
but
me, okay, so tell me why 81 Spooner is not the right, because my recollection is consistent, wait, my recollection is consistent with his, that the Foggs, the mom and the son who had houses nearby said, the neighborhood, it's getting so crowded. And I thought, that can't be enough, and it was enough.
Except it's not when you get to Murchison, which is 8 years later. And so that's why I
Murchison overrules
Murchison
81 Spooner?
It's the same court. It's the same analyses. It doesn't overrule it. But Murchison is a major sea change for all of us in the zoning area.
Okay.
You have 81 Spooner in 2012. Murchison came out in 2020. I know it quite well because, quite candidly, in this case, when I filed my original answer, Judge Foster asked me, because it was pre-Murchison, are you challenging standing? Murchison came out, I amended my answer.
Okay, so Murchison is what we look at. I get it. We look at Murchison.
So I would look at Murchison. I would also look at Stone v. the ZBA of Northborough, which came out a week after our brief was filed. Your Honor, it's 496 Mass 366.
I know it, yeah, okay.
That's the most recent iteration by the SJC on this issue.
Okay.
I mean, quite candidly, if you took the Bonanno's view of density, it comes back to somewhat of the question Your Honor asked before. That would mean any time anybody was adding a home, that's density, that's zoning, that's standing. That's not what Murchison and the subsequent cases talk about. You've got to have an individualized harm, not a neighborhood harm. And that's the distinction. And that's what Judge Foster did in his decision by distinguishing between what's going on Sleepy Hollow Way in general and what's going on in the easement in particular.
Okay, so let's go to, I got that. So let's go to, unless anybody else cares, let's go to the easement argument.
Yeah.
Okay, so it seems that there's not going to be a problem with regular cars. Everybody can do a three-point turn, everybody can, but they're making these points that the impact on, I think that we got to it at the end, the impact on their property rights is there are things that they will not be able to do. And I guess they are, most importantly, trailers with boats that they've done in the past that they like, and big box trucks that are bringing deliveries. And I guess the landscapers and the snow removal people are going to not be able to get down to the property. And what's the answer?
Because it's not what they will not be able to do, Your Honor, it's what they might not be able to do. In part,
speculation.
Yes, and in part it's precisely the question that Your Honor asked, why can't you park and walk? And depending on the size of the vehicle, the Q&A at trial, was fascinating. There was really no disagreement between the experts. Everybody agreed the 3.1 site triangle, the 6 inches.
It comes down to 6 inches 6 inches of the deck.
6 inches actually impact on the triangle.
Right.
So everybody agrees on that. Again, we have a lack of evidence. The only person who testified from the Bonanno side as to what was going on up and down that driveway was Charles Bonanno. Not a resident, somebody who was there frequently. We didn't have a single bit of testimony from the landscaper. We didn't have any testimony from any delivery people. We didn't have any testimony of anybody who ever observed.
Hold on, but let's assume for the sake of argument that it's adequate factual basis that in the past there were boats, the 5 boats the family has owned have been driven down with that driveway with trailers. And in the past, big box trucks have come down there. And in the past, the landscapers for 40 or 50 years, landscaping long trucks came down the driveway. And why is that not enough?
Because what we don't know, Your Honor, is were they driving head in or head out? Were they driving in forward?
Mr. Loeb, I appreciate your exuberance, but do not point at us.
Oh, I'm sorry. What we didn't have was evidence were they driving in forwards or were they driving in backwards. And that's where the speculation is. Because I think as Justice Meade picked up on a question was asked, there was no, if somebody is driving out of the right-of-way forwards, whether they are in a passenger vehicle, a small truck, a big truck, they have no impact on vision. So therefore, there's no impact. It's de minimis. What we don't know, and there is absolutely nothing in the record.
Can you actually backing up to the standard?
Sir,
we had an aggressive.
We're on the edge of our seat. What is it that we don't know?
Okay, sorry.
What we don't know is to what extent was anybody driving in forwards or backwards, and so hence we're now in speculation, which was the basis for Judge Foster's decision.
Okay, so we had an aggressive back and forth about the relevance of de minimis in this standing trial. So we're having a standing trial. I get it, it's a preliminary question, not on the merits, but on the merits of standing. Do you have a complaint about, do you have a real complaint? The real complaint, which is recognized under zoning law, is that it will have an impact on our use of the easement. And it seems that the answer is yes, they've announced a real complaint. And now the question is that de minimis? And if it's de minimis or speculative, you don't get past the standing trial. Am I right about that?
Absolutely correct, Your Honor. And that's, the SJC is most recently as the Stone case.
Okay,
lays that out.
Thank you. Okay, and so your point is this is either speculative or de minimis, this concern about landscaping trucks and boats, trailers, right?
Yeah, that was the point.
Right.
Judge Foster called it speculative.
I'm sorry.
Judge Foster characterized it as speculative.
Yes, because because there was no evidence were people driving in forwards or backwards. And so therefore, we're now speculative as to whether or not this is going to have an impact. Because, I mean, the testimony that we got into at trial, and it's in the record, is if you're driving a boat trailer, you are quite candidly more likely to back it in, because on this driveway to do otherwise, the vehicle is then stuck behind the boat trailer. In the same way for the landscaper, but because of the physical layout of the property, the landscaper was more likely to back down with his trailer and the truck in the back because that's where the lawn was, as opposed to driving head in which case he wasn't getting from behind the truck to the Bonanno property. So there was testimony in that regard that supported Judge Foster's finding of speculative.
Charles Bonanno Jr. was the witness?
Yes.
And was he testifying from firsthand knowledge, or was he testifying from information he received from his dad?
Oh, his father had absolutely no involvement. His father, his late father was a trustee of what I understand to be a special needs trust. So Charles Sr., as far as we knew, had no involvement. It was Charles, his son, who testified at the 30B6 deposition. Charles, the father, had no involvement. Unless the court has further questions.
Seeing none, thank you.
I'm prepared to rest. Thank you.
Thank you both. Our last case is 24P1048, John Doe 528364 versus the Sex Offender Registry Board.
for Gloucester.
As counsel knows, this case is impounded. So
Good morning, Your Honors. I know that's the last case of what's probably a long morning. I think I can be succinct, but I do think this case presents a very interesting salient question. I want to emphasize at the outset, I think all of the salient facts, the critical facts, are undisputed. So we don't need to deal too much with that. But the question that I distill this down to is as follows. How does one protect themselves from a public assault by a stranger? It's something maybe we all think about from time to time, being on the tee as I wade off. And how does one protect themselves from that? And the answer is, it's essentially impossible.
Stay in the house.
Stay in the house and never go out. Exactly. Is that what it boils down to? In this case, though, in any SORB case, we're talking about how does dissemination, assuming it's level 2 with dissemination, how does it protect a stranger victim, such as the victim in this case, from a public attack by Doe?
So at the time, Doe was a taxi driver?
Yes, sir.
At the time of the offense?
Yes, Your Honor. He was a taxi
Governing
driver.
offense. He was a
And
taxi driver.
Yes, Your Honor.
And do we know whether or not, was it a taxi or was it a car service of some other sort, like Uber or something else?
It was an unmarked taxi cab for something called Nuno's Taxi. So it was a taxi service, but it was an unmarked car.
And do we know that if we, and I don't know, I don't take Ubers and what have you, when you call for the service,
Yes.
do they tell you who the driver's going to be and who to look out for, and do they send you a picture or a picture of the car? Or I understand some of that information these days is conveyed to the person who's getting the ride.
Sure. So that is not in the record in this case. And I think in this type of case, everything we do is very tightly knit to the record. If I had to speculate, I would say the answer is no. At the time of the case, this seems like, it's a taxi cab. So I think we know kind of as we sit here that when you call a taxi, you don't get any information about the driver. When you get an Uber or a Lyft, you do get something. It doesn't give you his background, but it gives you, how highly rated is he and things like that.
But if it's on the internet, then perhaps would-be victims would be able to recognize him and not get in this unmarked taxi.
Well, we don't know that. So we have to decide this case, the royal we of the court, based on what the examiner said, based on what she wrote. The court cannot supply new rationalizations or sort of post hoc determinations. And I think, respectfully, Justice Meade.
Well, that's just a general reason why there's any putting on the internet. It's a matter of notice.
So it's a matter of notice, but it has to serve a specific protective function. That's DOE 496501, and it couldn't be clearer. So notice is a very sort of limited articulation of what the notice needs to do, what the posting on the registry needs to do.
Well, wait, but they can, in the registry, can somebody check folks in their neighborhood? So in other words, if he lives in the neighborhood and is being posted, if people in the neighborhood are so inclined to check to make sure there are no sex offenders in the neighborhood, they could find him that way, right?
Sure.
So in other words, that's valuable that's a purpose of this notice. That is the purpose of this notice requirement, right? In other words, you started off framing this question as how do you protect yourself from a stranger? Well, I get the point you're making, but if people in if his neighbors want to know that he's a neighbor and he's been convicted of a sex offense, that's the purpose of this notice, right?
It has to be very, very specific. Again, Your Honor, I think if you read the Doe case and the specific language it uses, it talks about crimes in the nature. So Doe tells us, 496501, and I promise to respond directly, but it discusses, it says that the examiner must consider what type of crime the offender would likely commit. And the decision states that the underlying facts must clearly dictate that dissemination is required. Now, what does the examiner say here? She says if he were to reoffend, it would likely be against a stranger woman in a public place setting. And in the SORB jurisprudence, Justice Wood, you're probably familiar, but it's tied to specific factors. So the word stranger victim is a technical term under this jurisprudence, so is public place. So we sit here with this being the holding of the case on dissemination, and we have to evaluate it and measure it against 496501. So, yes, she searches the registry, a given woman in the neighborhood. And if she calls up my client, she's going to see indecent assault, 3 counts, and his photo and his work address and his home address. How does that help her? What does she do?
Maybe she's more careful when she comes home at night, at midnight, by herself.
But how does she, what's going to cause her to do that, Justice Desmond? That sounds reasonable enough, but why? What about this information prompts her to do that?
Sorry, I'm not sure. Anyway, if she knows that on her block there is a guy there's this guy, yep, then I think she's going to never come home alone at night without taking some precautions. That's the answer. In other words, it seems really helpful in an obvious way to a person who's concerned about being a subject of a sexual assault to know that a sex offender is on their block. That seems common sense.
I think the efficacy has to be more specific than that, Your Honor. In the community where, my client currently resides, there's 33 offenders close by. And that's, so what is our theoretical woman to do? She looks at, in some communities, I'm sure it's more. I've had friends tell me, it's shocking to see how many level 2 offenders, and I think that's part of the problem, Your Honor, is just almost from a public policy standpoint, but tying into this legal element here, who does it help if the registry is cluttered with people such as, this gentleman who's well on his way to rehabilitation?
So I think your argument is he shouldn't have to register because there are already so many other people registered. Is that the argument? Because therefore it's ineffectual to have him register because we've got 33 in the neighborhood, now we'll just have 34 in the neighborhood, and so that won't make any difference. Is that the argument?
Everybody's doing it?
The term required to register, he's going to be required to register.
Sorry, internet posting. What. Right. I take your point. We're going to require internet posting.
Yeah, which is a very significant constitutional intrusion.
No, accepting that it's a very significant constitutional intrusion. The question is efficacy. You're really saying it's not efficacious, it's not effective because there's already lots of other, well, first of all, is that in the record? Is there anything in the record that supports that I didn't see that in the record.
About the number of people in the registry?
Yeah.
No,
the number of people in his neighborhood that are sex offenders.
No, that's my sort of, forgive me, I'm not trying to imply that's in the record. I'm just trying to respond to your common sense question.
Okay, but in other words, it's for all we know, he's the only person on his block who's a sex offender who's required to have internet posting.
Well, I think that I would respectfully part company on the for all we know. I mean,
it's speculation to say that it wouldn't be effective because there could be lots of other sex offenders in the same neighborhood.
Well, I think it's greater speculation to assume that he would be the only one. I mean, either one is speculation, but I think the far more informed speculation, at least in greater Boston, immediately around us, is that there are a lot of people on the internet. So let me give an example of where I think efficacy is clear in this kind of case. Let's say that you're a woman with 2 small children, and you want to find out, is there, a child offender in the neighborhood, a multiple serial child offender? That's where this registry theoretically could help. This dissemination could really help. And again, as a matter of affirming or reversing an administrative agency, we have to look at what the examiner said. The court cannot supply a new rationale, and I just think this its rationale is woefully short of 496501. But an examiner certainly could find on my hypothetical that, well, you know, look, we have an offender here who's a multiple serial offender against children, and therefore it's reasonable and helpful for people next door or down the block to know that. What are they going to know about him? My client, I mean, the offenses are serious. The index offense is serious. All women should be protected from an offense like this.
Is there precedent? I guess that's sort of an interesting question. If there were precedent that supports you that merely one indecent sexual assault against a 17-year-old stranger is insufficient on a public road, is insufficient to warrant internet posting. Is there precedent for that?
So you're asking, is there a case that says, and it's sort of almost squarely on all fours?
Or as close as you can come.
Well, I think there are ample cases, including, you know, Doe 496501 itself and other cases I've cited on my brief, where it's found that the rationale was insufficient to satisfy the case. As far as being this directly on all fours with this, I would say no, but I think that you know, you state the facts aptly, Justice Wood, that we have an index offense which is serious, and we have the null prost offense. And I stipulate as well that, you know, that was an alleged offense. It was null prost. With that said, the conduct as stated in the police report, no woman should have to be the victim of that. In a perfect world, we would protect all women from that. But being able to search the registry does not protect a woman from that. I respectfully think it does require leaps of logic and speculation. It requires us to surmise that someone is going to sit down and say, you know, generally there are a lot of sex offenders, or even just a couple. Let's say it's just a couple. What am I going to do? What is going to actually you know, help me prevent this from a spontaneous public attack?
Do you think it would be fair for those women in his community if they saw that he was routinely bringing his cab home and they looked it up and they saw that he was a registered sex offender, that they would say, I'm never going to take that taxi service?
Sure. I guess theoretically, yes, but there's nothing in the record that he had, you know, the record is indicative of him having different employment at the time of the hearing in construction.
Landscape, right.
Yeah, so there's nothing in the record that indicates that he's still a taxi driver or, frankly, ever would be.
Well, maybe she wouldn't want...
He was for the index offense, right? And that was fair for the hearing examiner to consider that.
Sure, it was fair to consider, you know, that it was a person of trust situation, a position of trust.
All right.
And a contact offense against a stranger.
Absolutely.
And she would, if she consulted the internet and saw this guy, his name and where he lives, and she's hiring landscapers, and she sees that he's one of the landscapers, she would be wise to stay away from him. Why doesn't that serve the public interest?
I mean, to me, that requires several logical jumps and inferences, which have to be, that they're insufficient when measured against clear constitutional precedent.
Under what circumstances, from your point of view, would it ever be appropriate to post someone's information on the internet?
Well, I gave one as far as the child offenses. I would say if you had an examiner, let's say there were multiple sort of date rape, I hate the terminology, but those kinds of offenses in a private setting, someone that meets people constantly on Facebook and rapes them, would it help to have his information there so that someone could, next person who looks him up on Facebook?
Well, there has to be multiple index offenses to make it appropriate to post on the internet.
No, I'm not saying that. You just asked me, Justice Meade, if there were, you know, what context, if ever, would you say there are dissemination would help? That's one. I'm not going to limit it to that. I could posit a situation where...
correct me if I'm wrong, but the legislature decided that they weren't going to limit internet publication to just level 3s. They're going to do it on level 2s.
Well, absolutely, Your Honor, but again...
Which seems to create a problem for you that only the worst of the worst should be posted on the internet. The legislature seems to disagree.
No, I mean, I think that you have to look at the precedent. That statement about what the legislature said bumps up against Chief Justice Gantz and a clarion statement about what must be shown. So, worst of the worst, terminology like that, it bumps up against the precedent, I would say, Your Honor. And I would just ask the court to engage that precedent in these questions.
Thank you very much.
Thank you, Your Honors. I appreciate it.
Mr. Bova.
Good afternoon. May it please the court. Christopher Bover on behalf of the Sex Offender Registry Board. Piggybacking on what my brother argued before you in terms of the efficacy of online publication, in terms of 496501, at page 655, I'll read the quote right from the case. It says, where a sexually violent offender presents a moderate risk of reoffense and a moderate degree of dangerousness, internet publication will almost invariably serve a public safety interest by notifying potential victims of the risk presented by the offender in their geographic area. So that's essentially what the panel was discussing with my brother, and it's exactly what this case is all about. You have a contact sex offender who offended against a stranger victim in a public area under a position of trust, and he committed a contact sex offense. I would suggest that if this isn't the type of case where public notification is warranted, then as Your Honors had pointed out, there's really no such case. And I think that's what my brother's argument was tending towards, is that in no instance should public dissemination occur unless it's a child victim he mentioned or a date rape, very specific instances. That's not what the case law says, and that's not what 496501 says, which is obviously the seminal case with respect to the elements need to be proven by our hearing examiner in these particular cases. I think in this particular case, you have an individual, the hearing examiner, who found that this particular offender was at a moderate risk of reoffense, was at a moderate degree of dangerousness, and their public dissemination was warranted. I know my brother challenged in his memo the reasonableness of the risk of reoffense and degree of dangerousness decisions-making process of the hearing examiner. I would suggest they are reasonable, and I think they are supported by the evidence. The hearing examiner listed the factors in which he believed were applicable based upon the evidence in the case, and then obviously considered the risk mitigating factors and weighed those two in a very lengthy discussion at the end of the decision after taking approximately 15 to 20 pages to discuss the facts of the case and how they apply overall.
What's our standard of review?
I'm sorry?
What's our standard of review?
The standard of review is substantial evidence, Your Honor. Whether or not a reasonable mind, I forget, I put it in my brief in terms of whether or not a reasonable mind accepts as certain. It's been so long, I haven't spat that out in a while, but it's substantial evidence. And in this particular case, the hearing examiner's decision, I would suggest, is supported by substantial evidence. There's no error of fact committed by the hearing examiner in this particular case. I would suggest there's no error of law committed by the hearing examiner in this case. I would suggest there's no constitutional errors that has been committed by the hearing examiner. And the case law would specifically suggest that the hearing examiner maintains the discretion under the case law to determine the applicable factors as well as the weight given to those factors. As long as it's reasonable, then this court should defer to the hearing examiner's decision. As I would say, this hearing examiner did outline what the evidence presented, and then also made a reasonable determination that given the facts of this case, given the fact that he offended against a stranger victim in a public place, in a position of trust, contact sex offense, that a level 2 is warranted. The other argument my brother brought up was the hearsay argument regarding the non-sexual violence that the hearing examiner used to apply factor 10, given minimal elevating weight, as well as factor 11, giving moderate elevating weight to her overall analysis. And I would suggest that the fact that the police report in that case, the police officer saw in first person the crime being committed. So in terms of the indicia of reliability as outlined in the case law, the fact that that officer, as well as an independent third witness, also told the police officer that the petitioner offended against that victim, I would suggest that those indicia of reliability makes the hearing examiner's application of factor 10 and 11 reasonable and warranted given the circumstances. And then when you apply the factors all together, I would suggest that, again, the hearing examiner's decision is reasonable. So unless the panel has any other questions for me, I can rest on the brief.
Seeing none, thank you. Thank you both.
Thank you so much.
That'll conclude today's session. I'd like to thank my panel, our law clerks, our court staff, clerk's office, and our excellent timekeeper, and we will stand in recess.
Court.